All right, well, good afternoon, everyone. Welcome to the Judicial Proceedings Committee, and welcome to, is this our first in-person hearing since post-pandemic? It's good to see you all. Welcome. So today we have 9 bills on the docket, and we're going to start off with Senator Sidnor, Senate Bill 106. We'll then move on to Senator Beidel, Senate Bill 99, Senator Brooks, Senate Bill 12, and then 71. And then we'll go on to Senator Heddleman, Senate Bill 100, Senator Ellis with Senate Bill 123. Then we'll come back to Senator Sidnor with Senate Bill 11, Senate Bill 43, and then Senate Bill 58. That may be subject to change based on senators' availability and folks that will be testifying in different committees. So without further delay, we'll start off with Senator Sidnor with Senate Bill 106. Senator Sidnor, you're up.
There we go. Good afternoon, committee. If I could have my panel join me, Mr. Hinton and Ms. White. Oh, shoot, I'll be right back. Wrong folder. Yeah, absolutely. All right. For the record, Senator Charles Sidnor to present on SB 106. Good afternoon, Mr. Chair and members of Judicial Proceedings. Today, this bill is essentially us revisiting the bill that we had heard last year dealing with garnishments and a certain exemption for $500. The bill as presented, there's been some negotiation over the course of the past few weeks. So with those negotiations, some of the text in the bill is actually going to be subject to change. So what I would like to do, rather than going through the written testimony that I had intended, is I'm going to ask that Ms. Marceline White and Mr. Hinton present and tell you about the conversations and the negotiations that they've had, because I think we've had the bankers and our consumer protection folk actually come to a good meeting of the minds.
So is this like a pre-Kumbaya moment that we're about to have here? This is
way to start off, right?
This is awesome. All right. I can't wait to see this. All right. There you go.
Chair, members of the committee, good afternoon.
Would you mind saying?
Oh, sure, sorry. Chair, members of the committee, good afternoon. My name's Marceline White. I'm Executive Director of Economic Action Maryland. We had a name change, formerly Maryland Consumer Rights Coalition. We are a statewide organization working on economic rights and equity. I am happy to be here today in strong support of SB 106. This bill had passed the House last year and was heard in this chamber last year. And as Senator Sidnor mentioned, we have been speaking to our colleagues at Maryland Bankers, and we are in a place where we are conceptually in agreement about some changes to the bill that we think will be positive for consumers and address some of the concerns that the bankers had. Just for those who were not here, I know there were a number of new members. Briefly, what the bill does is it creates an automatic $500 protection in bank accounts for people who have had a garnishment. So if a debt collector is seeking to collect funds, you will be able to keep $500 automatically in your bank account. That allows you to have, meet your basic needs, provide enough money for medicine, food, your essentials. Now, Maryland has a $6,000 wild card exemption. My colleague at the AG's office, and Mr. Hinton, can talk more about that, but most people don't know about that wild card. You have to elect it, and many people don't. The protection here is that it's automatic, and this $500 will be automatically protected. We know from the work we do that many of our low-income consumers are facing increased cost in rent, in utilities, and in food right now. So this $500 protection will be very meaningful for our estimate is about 50% of the people who do have their bank accounts garnished. And I will just mention that what this will do, and Mr. Enman will talk more, is it will create a snapshot one-time review of the account and provide protections and a safe harbor for banks. I will allow him to talk more about the language that we're agreeing on, but I will say, as you all know, we don't often have all these combined moments, but I think this is a place where we're in agreement of strong protection. So with that, I will ask for your support on SB 106.
I like that, the new innovative ding. That means I don't have to cut people off this time, so it's great. It's like, I can be nicer now. I can.
You know, Chairman Wilson on the House Economic Matters Committee always refers to me as Dr. No, but today I'm Dr. Yes with some changes. So, this bill was in last year, and for the banks, it's a procedural issue. It's not a substantive issue about whether anything else. It's much more about it's a procedural issue, and we've never had to deal with an automatic exemption that judgment debtor has to claim it. And there is a $6,000 cap. That's always been the law for decades in the state of Maryland. That's the maximum amount of exemptions that a judgment debtor can claim. Now, a judgment creditor garnishes the account files a garnishment, it's served on the bank, and the bank files an answer and discloses how much money is in the account. The bank has no way of knowing whatsoever that the debtor, judgment debtor, that's what they're called, judgment creditor, judgment debtor, that the judgment debtor has reached the cap. And what concerns me as general counsel to the Maryland Bankers Association and their lobbyists for many decades is that we don't want to have exposure to the judgment creditor if we turned over to the judgment debtor if we turned over money in excess of the cap. So one of the amendments we've talked about is an exemption from liability if, in fact, we turn over money in excess of the cap because of the $500 exemption. That is the main drift of our amendments. There's another amendment that deals with what happens if you have multiple accounts, allows the bank to choose which account to take the money from. To freeze the money. The other provision that's in the bill is what's called a snapshot. So Maryland is, states deal with this differently. Maryland is what's called a continuing garnishment state. In Maryland, the garnishment, the writ of garnishment hits the bank. The bank freezes that amount, and if additional monies come into the account, and it can happen because of a direct deposit from an employer or from some other source, or maybe the judgment debtor just doesn't really understand what the garnishment means, that money is also subject to garnishment. Well, not wearing the hat of a judgment creditor, and sometimes, believe me, banks are judgment creditors, just looking more at the process, that makes the garnishment process in Maryland much more difficult than it is in states that have what's called a snapshot. And in a snapshot state, the bank reports what was in the account at the time the garnishment hit, and if somehow more money goes into the account, that's not subject to the garnishment. Now, I don't think the debt collectors like that particularly. I wouldn't, but it's just something that would help facilitate and make things easier for us, so we support that provision as well. And with those changes, we will not be opposed to the bill.
Excellent.
You can't sign up opposed unless amended, so
Got it.
I
hear you.
favorable with amendments.
I appreciate it. Well, thank you very much.
Okay.
We're going to take questions at the end, so whoever wants to go next, we can. Yeah.
So I can just say something briefly.
Sure.
Unless you prefer me to get up. So good afternoon, Mr. Chair and members of the committee. My name is Kat Hyland, and I'm here from the Office of the Attorney General's Consumer Protection Division, here in support of SB 106. Now, we filed favorable testimony. The discussion that you're hearing is something we're familiar with. We have heard about a conceptual agreement, and when we vet the full list of terms, we'll be able to say that we agree. So that's where everything is, since this is a developing situation. I'm also here to answer any questions anyone might have. This bill was a recommendation from the Attorney General's Access to Justice Task Force, which looked at issues that impact underserved and impoverished populations, as well as populations that were suffering from pandemic-related issues. So it went beyond that and just looked at debtor issues too, and challenges that were made worse. So this came from the subcommittee that I chaired. I'm very familiar with the issues. And as you have heard, consumers are just surprised when these garnishments occurred. The bill gives people access to money when they really need it, and we're urging a favorable report. Thank you.
Hi, Mr. Chairman and the rest of the Judiciary Committee. My name is William Steinwhittle. I'm the supervising attorney for the Foreclosure Legal Assistance Project at the Maryland Legal Aid Bureau. We submitted favorable testimony in regards to this bill. We were not familiar with the changes, but I just wanted to give some brief background on how this sort of works in practice as a person who defends people who face this issue. So the $6,000 exemption is not well known for most people because, and the other thing is that if you don't do it before it happens or right when it happens, the adverse consequences that can occur due to a bank garnishment will still happen. So the account will be frozen. They won't have access to their funds. They won't be able to, use those funds, and this causes a lot of very adverse consequences. The first is that it causes like if your account's frozen and then you have to pay a bill like a utility bill or something like that to keep the electricity on or things like that, you would have to it causes some people to get things like payday loans and things of that nature. In addition, it promotes, and I have a lot of experience with this, having represented very low-income people in bankruptcy, is that it causes a lot of people to become unbanked, to basically say, I don't want to have a bank account. Because if I have a bank account, there's a chance that my creditors might touch it. And after a bankruptcy, very many times we had the discussion of, it's important to be banked, it's, because of things like tax refunds when they're deposited, things like that, they can cause very large interest rates if you go to a private lender. So, and we believe that bank garnishments, especially in the small amount, tend to harm poor people disproportionately, and $500 goes a long way for our clients. So we speak in strong support of House Senate Bill 106. Thank you.
We can make it louder. Yes, we can do that. Yeah, thanks. All right. Also an ejection seat too. All right. Questions from the committee. Senator McKay.
Thank you, Mr. Chairman. So, looking at some of the unfavorable testimony, and just a short background of who I am. Look, I am not an attorney. I don't even like Law and Order on television, but I'm just a simple guy, and so I just boil it down to simple. So I am a landlord, a small landlord, 5 or less units that I live with. So I get the $500 exemption, but my question runs, it was stated that this is money that the tenants for rent, for food, and for utilities. Well, how does the small landlord, I've got a family of 8, and when somebody doesn't pay their rent, it affects my family. And I'm the one that's normally giving out, helping everybody out. Look, I am a second chance guy beyond second chances. But at some point, if we have to go the route of garnishing wages for back rent, where's the voice of that person? So that's one question. I don't know anybody.
There are a couple ways to answer it, but I just wanted to offer that another perspective, which I don't think is the one you would have because you're the landlord's position here, which is great. is that we had asked for more money to be exempted originally, and $500 is a compromise. But the first figure that we came up with was twice the median rent for Maryland. It was approximately $2,600 because it was, median. So that idea is something that maybe we could revisit, but that would allow people to pay their landlords and still have some money left over. The $500 is in hopes that they just don't default on something, have repossessions occur, can't get to work, lose their job, and then have no chance after the garnishment of, paying you back. So that's just offering another perspective, because I
Yeah,
get your point.
and I get that, and actually, full disclosure, I've had financial problems. And when it comes to a garnishment or whatever, fees that get dropped on, and it's a cascade, so I get exactly where you're coming from.
I think the other thing, sir, is that you can still garnish their wages. This is simply on their bank account garnishment. So just to be clear, this does not affect their wage garnishments, which is, yeah.
Okay. And then, if I may, Mr. Chairman? So we had talked about, not too many people know about the 6,000 asset protection. So what are you all individually doing to educate the masses that give them this opportunity? Back in the 70s, litter-free America, we were educating everyone not to litter. And I tend to believe we got away from education and we went right to the stick. And so now our highways are all full of litter because we didn't educate somebody. We tried to change behavior in a different manner. So my question is, what are we doing to educate?
Oh, that's a very good
Mr.
question.
Senator.
In fact, we were discussing that just about an hour ago. And so there are a few ways, if you think about things of path of least resistance. Ms. White was talking with the executive and seeing how they might be able to do PSAs or something. We've wondered about the modification of forms, but that would have to be done by the judiciary, and sometimes the judiciary doesn't necessarily like us telling them what to do.
Really?
No, they don't like that at all. Right, Senator West? So there are some options that are out there, and they are being examined.
There was a very successful campaign called Mortgage Late, Don't Wait, during the last foreclosure crisis. So talking to the current administration about something similar around get your $6,000 if you're in debt is the type of thing we could do that would be a PSA campaign around the place where low-income consumers may go, and working with community action agencies and things like that is something that we could envision. And again, if the judiciary is open to it, or working with this body and our friends with the bankers and the creditors bar to create new forms that the judiciary might be willing to do as well, because they're not friendly. I attached it in my testimony, what the form looks like, and you will not understand it unless you're a lawyer or you have a lawyer with you.
Well, thank you very much. Appreciate you answering my questions.
Thank you for the questions.
Like I said, my questions may come a little bit harsh, but but thank you. Thank you, Mr. Chair.
Thank you, Mr. Chair. Just a quick question for Mr. Enton. You talked about the difference between continuing garnishments and snapshot garnishments. Maryland, as you indicated, has always been a continuing state, not a snapshot state. I was a little confused. Is the bill as amended going to turn Maryland into a snapshot state?
Those will be the amendments, part of the amendments that we've agreed to with the proponents for the bill would turn Maryland into a snapshot case.
Would do that, okay.
Yeah.
Fine, thanks.
Additional questions from the committee? All right. Excellent. And then, just to be clear, so the wild card is $6,000 assets or it could be cash in your bank. And this is now, you've come to the $500 agreement for $500 additional. Okay, that's all I wanted in the snapshot. And then, I don't want to mess up the deal, so we'll toss this out here and then we'll go. But maybe, thinking about indexing or something so that we wouldn't have to come back. I know that's probably been in the back of your mind, and I see that Mr. Enton is now smiling, is fading off of your face. But just so we're not back here every couple of years, that's all. something to put in the back of your head.
My mind.
Yeah.
It's definitely in the back of my mind.
Okay, got
I
it.
won't be back. trust me.
All right.
Thank
Wait,
you
this is
very
great.
much.
Great work. This is awesome. Thank you very much. Appreciate
Thank
it.
you.
All right. All right, we'll go to the next, we have a few more witnesses. Is Mr. Peters here? And then we'll go to Michael Lagana and Michael Best. And Michael Best is virtual, so we'll bring him in afterwards.
May I proceed? Good afternoon, Mr. Chairman and members of the committee. My name is Scott Peters. I'm on the Board of Directors of the Maryland D.C. Creditors Bar Association. I'm also a partner of the law firm Klima, Peters, and Daly. I have represented creditors for the past 20 years almost exclusively. So needless to say, I've been on the front lines of all of this. I've seen the results of bank attachments. I've seen how they work. I've received calls from consumers. And that being said, I understand and I appreciate the need for this $500 automatic exemption. So today I signed up as favorable with amendments. So I'm favorable to the $500 exemption. It's necessary. It's needed. However, there are a couple of issues with the bill as written. A few concerns I have, and I think Mr. Enton did bring this up. A banking institution has no way of knowing where the judgment debtor stands as far as this $6,000 exemption. And I guess I came up with an idea. I think the judgment creditor, that is the entity or person filing the bank attachment, is the person or entity in the right position to know where that exemption stands, whether it's been exhausted or not. So I haven't talked to the other parties yet on this issue, but I'm proposing we do something as simple as putting a checkbox on the bank attachment form. And that checkbox would indicate to the financial institution that the $6,000 exemption has been exhausted. I would further state that to protect the banks, they should be absolved. They should be absolved from any liability if they rely on the creditor's checkbox. So that does away with the issue of whether or not the banks even know where the $6,000 exemption is. I'd also, there's an issue here. There's an issue here as to whether or not this automatic $500 exemption should apply to an attachment or an account. So you could you could file an attachment on a bank, and they might have 4 accounts, and each account has more than $500 in it. So is this a $500 exemption, or is this a $2,000 exemption? And as written, I think it's unclear how that's meant to apply. And that being said, there's some discussion about switching Maryland's bank attachment law from a continuing to a snapshot, and the creditors bar would oppose changing what's been years of Maryland bank attachment law, changing this from a continuing bank attachment state to a snapshot. And I think this bill is aimed at an exemption, and it's the amendments proposed by, I think, Mr. Enton are seeking to change a lot more than just exemptions. So we are favorable as to the $500. However, we would oppose changing the entire process of bank attachments as has been suggested. Thank you for your time.
Good afternoon, Chairman Smith and members of the committee. I thank you for this opportunity to speak regarding Senate Bill 106. My name is Michael Lagana, and I'm here on behalf of the Receivables Management Association. RMAI is a national nonprofit trade association representing over 600 businesses, many of them in Maryland, that purchase or support the purchase, sale, and collection of performing and non-performing debt in the second market. I've appeared before this committee several times over the last 10 years, the wage garnishment bill we did, and the documentation and standards bill that we did a few years before that. RMAI is here in favor of support of Bill 106 with amendments. In theory, the automatic $500 exemption is completely acceptable to the association. I think it's a good compromise between the creditor's rights and the needs of the consumer. But as my colleagues have mentioned, in practice, there is no mechanism in place with which a judgment creditor can utilize anything to determine how much of the $6,000 has been claimed or not been claimed. I know all the parties here have been talking about a solution. I think the checkbox personally is probably the best way of doing it, because that the creditor has the most hands-on information regarding how many times a garnishment has been filed. The bank would not know that. So again, I'm here in support of Bill 106 with amendments, which I do believe we can work out in future discussions. Thank you for your time.
Thank you both very much. Questions from the committee? I think I'm definitely going to follow up about the continuous garnishment vice snapshot. It just seems like it's not an insignificant change, but I'm just not sure what the other implications of the change are, so definitely follow up. Senator Sidner.
That was going to be my question. What do you perceive as being the issue with changing over from what we're currently doing to a snapshot type of system?
Is that question directed toward me?
Yes, sir.
Thank you. The law in Maryland is always, I'm sorry. The law in Maryland has always been a continuing bank attachment. If the way that works is if a bank is served a garnishment today and they freeze $1,000, there is a 30-day period for the bank to file an answer confessing they are holding that $1,000. Contemporaneously with that, there's also a 30-day period for a judgment debtor to elect this $6,000 exemption. So there's a 30-day period running for both of those items. After 30 days, a judgment creditor will file what's called a request for judgment garnishment with the bank or with the court. If a court signs off on that condemnation order, condemnation judgment, it'll be forwarded to the bank. The bank at that point will pay whatever money they are holding in that account to the creditor. And if after acquired funds enter that account after the initial garnishment, those after acquired funds will remain garnished up until that judgment order, at which time the bank will pay that to the creditor. So that's been the Maryland law for as long as I've been practicing. The amendment suggested by Mr. Enton is seeking to change that, in that when the garnishment is served, the only funds that are garnished are those that are in the account on that particular day. And that is, of course, detrimental to the creditors. And it actually just limits the amount of funds that they may collect, and it would prolong the existence of judgments. Anytime they're getting less money, the judgments are going to last longer, and you're going to open up consumers to additional collection efforts down the road. I don't think the amount, when we see these garnishments come in and they confess 1,000 and maybe we get 2,500 once the order comes through, I don't see significant amounts of money, but every payment reduces a judgment balance more, and the sooner you get to zero, the sooner the consumer's out of the collection cycle. So for those reasons, I think it may help in the short term, but I think in the long term it might actually be detrimental to consumers because they're just in the process longer.
Thank you.
Thank you, Mr. Chairman. I admit I'm confused. When I was a very young lawyer, I did a little bit of garnishment work, not many. So this is far deeper in the weeds than I ever got. So let me give you a hypothetical. There's a creditor, he files a garnishment against a debtor, and in the bank account at that time, there's $8,000. And so the debtor protects $6,000 of it, and $2,000 goes to the creditor. So a year later, a totally different creditor gets a judgment against the debtor and tries to garnish the bank account, a different bank account in a different bank. How does the banker possibly know that a year earlier, a different bank had protected $6,000 for the benefit of the debtor? Wouldn't the second bank have no knowledge about that at all and would simply confess the amount of money that's in the bank account? Let's assume it's $10,000.
That's correct. The bank, a banking institution would have no way of knowing where that $6,000 exemption stands. So my idea to just add a checkbox to the bank attachment.
Yeah, but let's assume it's a different creditor. It's not the same creditor from a year earlier, it's a different one. How is the new creditor going to have any knowledge that a year earlier, a different creditor had garnished a different bank and the debtor had protected $6,000 at that time?
The new credit, well, I guess there's some uncertainty as to whether or not that 6,000 is per judgment or per debtor for life.
I assumed it was per debtor for life. It's
Well,
not?
I take the conservative approach. I take the conservative approach and I do it per judgment. Because I don't think it's clear to me, and I don't want to, the last thing I want to do is get my client sued. So I take the conservative approach and I track that per judgment.
I did do some bankruptcy work. And in bankruptcy, in Maryland, you're entitled to certain exemptions.
right.
And one of them, as I recall, is $6,000. So that's why I'm assuming that it's a one-time exemption of $6,000. So you're suggesting that the law may be sufficiently ambiguous, that a debtor can claim $6,000 here and then $6,000 a year later and $6,000 a year later?
Perhaps. And I'm saying
Wow.
in my office, I don't know the answer to that. I don't think there's a case on point. So we simply track the exemption per account or per judgment.
Interesting.
To avoid that situation.
Thank you very much. Interesting answer. It sounds like we need to look further into this. Thank you.
It's not as clear as it could be. And then, if I may, I'm also licensed to practice in the state of Virginia. Virginia has a similar mechanism, but in Virginia, they have a $25,000 lifetime exemption per judgment debtor, but you have to file something called a homestead deed. You're actually filing something, I believe it's in land records, to put the world on notice where this stands. We don't have something like that in Maryland, so I believe the creditors have to do the legwork, and if they want to come forward with that situation and say, oh, this particular debtor exhausted $6,000 2 years ago, then if there's a box on the bank attachment and that creditor checks it and says, this $6,000 is exempted, then that should put the bank on notice that they shouldn't exempt anything. They should just, the full amount should be attached and confessed.
Additional questions from the committee? All right. Thank you both very much.
Thank you.
All right, Mr. Best, you're up. Welcome.
Thank you, Chair Smith, and honored Senators of the Judicial Proceedings Committee. My name is Michael Best. I'm a staff attorney at the National Consumer Law Center, where my work focuses on state exemption laws like SB 106 and working with advocates and legislatures to increase these key protections. Just as a brief overview, state exemption laws are a fundamental protection for families. Without these laws, once a creditor obtained a ruling from a court that a consumer owed a sum of money, the creditor could seize the debtor's entire paycheck, bank account, car, and household goods, and even sell the debtor's home. Exemption laws place limits on these seizures. They're designed to protect consumers and their families from poverty, to preserve their ability to be productive members of society, and recover from financial setbacks. From our perspective, everyone deserves a fresh start. I'm the co-author of our report, No Fresh Start 2022, which states let debt collectors push families into poverty as the cost of necessities soar. We update this report annually to reflect changes in exemption laws and grade state laws on an A to F scale. Currently, Maryland has a D grade overall and a C rating for protection of the family bank account, as we believe a typical consumer would use $1,000 of a wild card exemption to protect that portion of their bank balance. This protection is not, however, currently self-executing. As a result, a family's bank account is likely to be frozen as soon as the court order reaches the bank, potentially creating an immediate crisis and causing a cascade of bounced checks, declined debits, and insufficient fund fees. The bill will create a self-executing protection for $500, making sure that a minimal amount of money is available to pay for any immediate family needs. Maryland's not the first state to recognize the importance of a self-executing bank account protection from debt collection. In Massachusetts, where I'm based, we have a $2,500 protection. California has a protection that's indexed to a state minimum basic standard of adequate care for a family of 4 that currently sits at $1,947. And New York protects between $3,168 and $3,600 depending on the minimum wage where the levy is taking place. All of these are self-executing protections. The consumer gets those without having to go to court. Thank you.
Excellent. Questions from the committee for Mr. Best? Then we definitely got to follow up. The Virginia model seems like it's 25 grand one time, but it's then if you've got multiple judgments and you're below, and you could be basically down to zero. Whereas I always thought the policy behind the 6,000 here was to make sure that you never drop below the 6,000. At least that's what I would have thought. So we definitely need to seek more clarity of the legislative history on that before we move forward. But additional questions? No questions from the committee. So Senator Sidnor and your panel, thank you all very much. That'll conclude the hearing for Senate Bill 106. We'll now move on to Senator Beidel with Senate Bill 99.
Mr. Chairman, can I bring up two panelists? Thank you. Clerk of the Court, thank you. Thank you for being here. So Chairman Smith and Vice Chair Wallstreicher are members of the Judicial Proceedings. Thank you for hearing Senate Bill 99 today. I appreciate the opportunity to present the bill to you. The circuit courts and district courts for dishonored checks and service charges is currently at $10. This bill would raise the current $10 fee to $30. As you know, there's just a lot of administrative costs when you have a check that doesn't clear properly. And so this $30 is what the comptroller is charging and most other services are charging. So I have with me two clerks today, Kathleen Duval, President of the Conference of Circuit Court Clerks, and Mr. Almin, Clerk of the Circuit Court for Prince George's. And if you could hear their testimony, I'd appreciate it. Thank you.
Good afternoon. Thank you, Chairman Smith and members of the committee for this opportunity to testify in support of Senate Bill 99. For the record, my name is Mahasan El-Amin, and I'm the Clerk of the Circuit Court for Prince George's County. The clerks of the Circuit Court support SB 99 and the proposed increase to $30 for dishonored checks. This has become an increasing problem for the clerk's office to process checks. The judiciary currently receives roughly about 720 dishonored checks each year. The fiscal year 2022, the total dollar value of these checks was almost $500,000. These are funds owed to the state of Maryland for fees that are collected by the clerks. The great majority of these dishonored checks are for taxes on property purchases, business marriage licenses, and fees related to civil lawsuits. One comment that we did receive while we were working on the proposed change was concerns from the Office of Public Defender with a potential impact that they may have on their clients with limited financial means. We understand their concerns by not adding an additional financial burden to their clients. And in response, we reviewed approximately 3,000 dishonored checks received by the circuit court and district courts throughout the state over the last 3 fiscal years. And out of the 3,000 returned checks, we eventually identified about 13 written by a client represented by the public defender. Therefore, if the service fee for writing a bad check was to the clerk was like $10, and we changed it to $30, we're talking about $260 over the 3 years. So we don't believe that this very limited impact would warrant keeping the service fee unchanged for the clients represented by the public defender. And I just want to reiterate, the most common dishonored checks we received by the clerks for circuit court clerks are for land records and licenses when payment is due, once we issue the land recording or issue the business license. So as Senator says, it creates a serious burden on the clerk's office. So given that fact, we would ask for a favorable report from the committee, and thank you very much for sponsoring this bill.
Thank you, Ms. Almin. We got to get signed up for that Baltimore Marathon.
We're going to get there.
Yeah, we're going to
You're
get
ready.
there.
It's hilly.
That's right. Yeah. All right. We had promised we'd do that like months ago. It's never happened. So, welcome.
Good afternoon, and thank you, Chairman Smith and Vice Chairman Wallstreicher, and members of the committee for hearing us and allowing us to testify in support of Senate Bill 99. My name is Kathleen Duval. I am the Circuit Court Clerk for Talbot County, and I am the current chair of the Conference of Circuit Court Clerks. Clerk El-Amin did speak about the administrative burden of these dishonored checks. As she said, a lot of them are from land records and business licenses, et cetera. We would really appreciate a favorable viewing on raising it from the current charge of $10, which hasn't been updated since 1978, to $30, which is the same level, as Senator Beidel pointed out, that the comptroller's office charges. Updating the charge to the $30 will more accurately display what it costs to handle a dishonored check. We get a check return from the treasurer's office. We have to amend all of our records to say that the required fee wasn't paid. Then the accounting records and disbursements that we've already dispersed out to the state and the counties and local offices, that has to be accounted for. And sometimes it has to go to the central collection unit, which is more burden on the state. And then if the fee does get collected, we have more work to do just to process getting that payment in. So as you can see, there's a lot of work just for one dishonored check. And the current fee of $10 doesn't come close. We hope it would provide a deterrent to people to give us dishonored checks. Therefore, the circuit clerks hope that you would give us a favorable view on Senate Bill 99, and we would like to thank Senator Bidle for sponsoring the bill, and thank you for the opportunity to comment, and we're available for questions.
Excellent. Thank you very much. Questions from the committee? Seeing none, thank you very much, Senator Bidle. That concludes the hearing for Senate Bill 99.
Thank you.
Thank you.
Thank you very much. All right. Senator Brooks is here. Yep. No worries. Senate Bill 12 with Senator Brooks. Welcome. The maiden voyage in JPR.
Thank you, Chair.
You look really excited.
Okay. Good afternoon. For the record, I'm Senator Ben Brooks. I want to thank you and this committee for allowing me to present SB 12. The bill is the Corporation and Association Annual Reporting Filing Fee, electronic filing exemption. Now, the purpose of this bill is to require the State Department of Assessment and Taxation, better known as the SDAT, to waive the filing fee for annual reports for those who file electronically, certain businesses. Currently, when a business is formed or qualified or registered in the state, they're required to file an annual report. The cost of this report is $300 payable to SDAT. And since 2016, there have been several variations of this legislation introduced to eliminate that $300 fee. This fee is already waived for corporations that do not issue stock, foreign interstate corporations, and businesses that qualify for an exemption under the Maryland Small Business Savings Trust, and that's Maryland Saves fee waiver program. While big corporations or companies may qualify for the fee waiver, we are leaving out the little guy. This bill targets to waive the fee for those businesses who file online with SDAT but are not eligible for the fee waiver that's offered by Maryland Saves. As written, SB 12, with SDAT's study findings and recommendations to the General Assembly on how to best amend the Maryland annual report fee and to make Maryland a little bit more business-friendly state for competitors and to do what some of our neighboring states are doing. This bill ensures that single-member LLCs, and some refer to them as disregarded entities, that filing electronically that are not eligible for Maryland Save, this will allow them to be able to not have to pay that $300 filing fee. And what it does, it will make Maryland a more business-friendly state. And then it eliminate those who file electronically, and then it eliminate the inefficient paper filing. So, and we do have the support of Maryland Saves on this measure. So for that reason, I'll ask for a favorable report. And I do have Mr. Jonathan Glasser here to answer any technical question from SDAT.
Excellent. Thank you very much, Senator.
Yes.
Vice Chair Walstreicher.
Well, Senator, welcome. Thank you for bringing this bill. Just a quick comment, and then isn't it so like, I am shocked at how much I hear about this fee from my constituents back home. My dry cleaner, the physical therapist, my tax accountant, who's just a one-man band. I hear about this fee all the time.
Right.
And people feel really put off that they're being charged for a simple electronic filing. For those of us who are attorneys, we do electronic filing all the time. and we're not paying a fee each and every time that filing is made. So anyway, isn't that so?
Isn't that so? Thank you, Mr. Vice Chair.
I guess the technical question I have is how much is this going to cost the state?
So good afternoon.
afternoon.
Jonathan Glazer again from the Department of Assessments and Taxation. The department and the administration is not taking position on this bill. Here for technical questions. The fiscal note is substantial, but I have to say our view is that it will bring more businesses into the state. Included in our informational testimony is a study that the department was required to do on this fee from 2 years ago. And essentially, we have one of the highest fees in the nation. This is this is just a filing fee that businesses get nothing for. It's money that goes directly to the general fund. It's not money for SSTAT. And we're getting to the point where there's a whole bunch of exemptions. However, some people are being left out. And if you're a single-member LLC with no employees, you're not eligible for any of the fee waivers. This fee was increased from $100 to $300 a while back, and the senator, and also there are several bills in the House that do that do the same thing as the senator's bill, would reduce this fee if the individuals filed online. One point that the senator, I just want to emphasize that the senator made, is he wanted to make sure this would not affect Maryland Saves. There was some legislation last year that was put in by the previous administration that, if passed, that would have sort of curtailed the fee exemption in Maryland Saves because you would be exempt across the board. The Senator Brooks's bill explicitly says that if you are eligible for the fee waiver from Maryland Saves, you cannot get the fee waiver from this bill. You still need to go through Maryland Saves.
Thank you. Senator Brooks, does this bill at all talk about the notification of said filing fee each year? Does it address anything like that? Because right now, we don't do the postcard anymore. It's just an electronic, and if you somehow get in your junk mail, you have no idea. So if we're going to help with the electronic, how do we address that? And for all disclosure, there happened to be a bill, something similar to that last year, so.
Oh, well, if my memory serves me correct, I think you get the notification if you're late. If you don't file it by, don't file for an extension to June 15th, you'll get a notification at that time saying that you haven't filed and there's a fee. But
you may have a friend help.
Thank you, thank you. So SSTAT has moved away from sending physical postcards to individuals. Obviously, you can sign up for your email notifications. Just as a rule of thumb, any business that is doing business in Maryland, so that doesn't mean if you have no sales, it means if you exist in Maryland, you have to file your annual report every year by April 15th. So it's just a good thing that we encourage all Marylanders to subscribe to our emails. If you can't meet that April 15th deadline, you can have a 2-month extension till June 15th to file, but then your business will be not in good standing if you don't complete it by that, that June 15th deadline if you filed for an extension.
Thank you, gentlemen.
Thank you.
Thank you, Mr. Chair. So I noted from your report, which I read earlier, that in Delaware, for foreign corporations, the annual fee is only $125. So here in Maryland, it's $300, in Delaware, it's $125.
Correct.
So I would assume that the lower fee in Delaware encourages lots of Maryland companies to form themselves in Delaware, not in Maryland, so they'll get cheaper fees each year. Wouldn't that make sense?
Absolutely.
And hopefully, if we reduce this fee or eliminate this fee, those companies will now file in Maryland rather than Delaware.
Yeah, as our report points out, sometimes the $300 filing fee is a prohibiting factor for some businesses forming in Maryland. If you form your business in December, your filing fee is due in a couple months. Technically, it's due April 15th of the following year. So it's a very quick turnaround time. You pay your $100 for articles of incorporation, and then you immediately have to pay the $300 for your annual report. So thanks for that.
So, but there is an opposition filed in this by the State Bar Association's Business Law section, We have a representative of that here in the audience today, so now, he says. Okay, he's out of loop on this. But they say they believe that the bill would make the filing process complicated because the cross-reference to the covered employer definition does not make it clear which companies could and would not qualify for the fee waiver. And they're suggesting that cross-reference be eliminated so that all companies would be covered by this. What's your response to that?
So that's a very simple, easy fix. The cross-reference to covered employer has to do with Maryland Saves. What Senator Brooks's bill goal was is not to have this committee keep revisiting this every year. So instead of defining what a covered employer exactly is, we just point to D1 of where it defines covered employer. Our expectation is Maryland Saves may change over time what a covered employer is. Therefore, we don't want to have to keep coming back and changing this bill. In practicality, if or when Senator Brooks's bill passes, SSTAT would simply have a checkbox on our annual report for businesses to determine if they are a covered employer or not, similar to how Maryland Saves has a drop-down menu where it's very clear what is a covered employer and what is not a covered employer. SSTAT would have a similar sort of checkbox or drop box, so I'm not concerned with their concerns.
Okay, so the form that is used for the annual report will make it clear whether or not the employer can waive the fee by filing electronically, or whether they're part of Maryland Saves.
Absolutely, and the nice thing is because this only applies to electronic filings, we can change our electronic page much easier than changing a paper form to reflect this.
Great, thank you very much.
Thank you.
I would just say the fiscal note is substantial. So it's $51 million the first year, and then all the way through to 2028, it's $68 million. So in this committee, we're not a money committee. We have a threshold of how much we could allocate. So I would just say, if there are efficiencies and savings and it's making us a more competitive business environment in Maryland, and therefore we'll see some more kind of revenue there on that side, I would try to outline that in a succinct manner, but then also I would definitely consult with B&T on this, whatever feedback they can offer, because I would have to check with them anyway if it's going to cost this much. So I just definitely want to work with you on it, but I just highly recommend we collaborate with Budget and Tax on this, and maybe Senator West, we can do some work on it or something. But, okay. Excellent. Thank you very much, Senator. Thank you very much. Thank you.
Thank you.
All right, I think that's it for your panel, right?
For that one, yes.
Yep, for that. So that'll conclude the hearing for Senate Bill 12. We'll now move on to Senator Brooks with Senate Bill 71. Welcome back.
Okay, thank you, Mr. Chair. May I bring up my panel? I'm sorry, I apologize. Okay. Okay. All righty. Chair Smith, Vice Chair Waldstreicher, and members of the committee. For the record, again, I'm Senator Brooks. Thank you for the opportunity to testify on behalf of SB 71. The execution of judgment, child support arrearage workers' compensation. The purpose of this bill is to specify that 25% of the net recovery of a claim for workers' compensation is subject to execution of a judgment for child support arrearage. Current law does not explicitly state what, if any, indemnity benefits can be attached while the child support order is in place. SB 71 merely offers clarity in an otherwise ambiguous statute in determining which workers' compensation indemnity benefits can be garnished. Yeah, the clarification is in the interest of the judicial economy and otherwise aligns workers' compensation recoveries with personal injury recoveries. For that reason, I request a favorable report, and I've got two panelists here. Mr. Albert Burt Randall, Principal of Franklin and Procopic, and also Caitlin McDonough from Chesapeake Employers Insurance, so that they can answer any of the technical questions. Yeah. Okay. You want to go first?
Sure,
Yes.
I'm more than happy to, Senator. Thank you. Thank you, Senator Brooks. Good afternoon, Chair Smith, members of the committee. My name is Burt Randall,
president of Franklin Procopic, where I also head the firm's labor and employment practice, and I've been a practitioner of workers' compensation for over 25 years, as my hairline would attest to. This issue, while seemingly a rather minor change to the existing statute, its significance is evidenced by the fact of the overwhelming support on both sides of the V. I would like to supplement my written testimony with a real-world example outlining the uncertainty and lack of clarity in the existing statute vis-a-vis workers' compensation benefits. Under workers' compensation law, when an order for benefits is passed, my clients, being on the defense side, must pay within 15 days. I had one relatively recent example where there were two competing child support liens through different child support enforcement agencies. One of the enforcement agencies took the position that 100% of the benefits should be withheld. The other enforcement agency said, no, it should be 25%, which the claimant's attorney agreed to. Nonetheless, using the idiom, no good deed goes unpunished, my client just wanted to issue payment, but was under threat of litigation from both one of the child support enforcement agencies claiming 100% and the claimant's attorney arguing that it was 25%. And no matter what my client paid, it was subject to litigation from the other party. As a result, this change provides clarity and certainty not only to all the workers' compensation stakeholders, injured workers, employers, insurers, counsel, but also the intended recipients of child support. And with that, we respectfully request a favorable report. Thank you.
Good afternoon, Mr. Chair and members of the committee. Caitlin McDonough on behalf of the Chesapeake Employers Insurance Company, which is also IWIF for all intensive purposes here in the state, in support of Senate Bill 71. Chesapeake's position on the bill is really more technical. We would leave it to the General Assembly to kind of determine that rate and how it would apply, but we would ask that it apply consistently across different types of worker compensation paid benefits. So if it's applying to a settlement, it should also apply to a stipulation. Those were amendments we worked out with then Delegate Brooks last year, and it's reflected in this year's bill, so we'll continue to support. I'm happy to answer any questions. Great. Oh, I'm sorry.
Thank you, Mr. Chairman. So, how many individuals are we talking about? What's the scope of this?
Anecdotally, I don't have the actual statistics in terms of the percentage. Anecdotally, it is something that my office handles certainly on a weekly, if not daily basis, in terms of the amount of injured workers who have child support liens that are both current and arrearages. And this would help simplify and provide certainty to both situations.
And with you representing that side of this issue, has there been any fathers' rights groups give some clarity or input whatsoever, or really they're not involved in this?
Not that I'm aware of. Going through this last year when it was submitted and this year, I'm not aware of any. And for the committee's reference too, is at the early part of my career, I also represented injured workers and faced this issue in my first several years of practice, as well as the last 20 years on the defense side.
Thank you.
Thank you.
Thank you, Mr. Chair.
We'll now hear from Mr. McAvoy. I actually met Mr. McAvoy in Washington, D.C. when I was coming out of my firm a couple years ago. Good to see you.
Great to see you again, Chair.
All right.
Thank you so much.
Welcome.
And thank you. I appreciate it. And welcome members, new and old. I really appreciate the timeliness of your comments, Senator McKay. Welcome to the Horseshoe. I actually did bring this up, and you'll see my testimony from last year when it was Delegate Brooks that brought the bill. I do see some cleaning up. I see that we had some problems with the breakdown of different types of disability, but I want to offer this overall theme that should be considered. When this happens, and I've been in workplaces, in manufacturing workplaces, where people have lost their fingers, people have had their sight impaired by hydrofluoric acid splashing in their eyes. These are serious situations, and they are not always made whole by any means by 60% of this disbursement in workers' comp. What this will do will make it easier for the lawyers so they don't have a grab ball. We saw a similar thing, we'll use this anecdotally, from what Delegate DeMay used to bring, this multifamily issue. And they just wanted clarity, right? Because these are billable hours. But if you're really talking about these parents and these families, what you don't want at a time when someone can't work is complete upheaval in their lives while they're trying to make child support payments, while they're trying to feed them and probably their children, hopefully 50% of the time, definitely on the weekends, while they're trying to provide other things intangible for the children. This is going to make things a wreckage. I strongly urge that the committee look at this bill askew. I do see some changes. I don't think they're noteworthy. This bill should be dismissed out of hand simply because it's just not serving the people and our families. That's the important thing, just to make these lawyers' lives easier. Thank you so much for your time. I'm available for questions.
All right. Questions from the committee? All right, seeing none, thank you very much, Mr. McAvoy. And with that, thank you, Senator Brooks. That'll conclude the hearing for Senate Bill 71. We'll now move on to Senate Bill 100, Senator Heddleman. I know that Senator Heddleman's aide is going to present. And if she's not here just yet, we'll move on to Senate Bill 58. Senator West, are you? Hold on, never mind. Is she here? Yep. All right, there you are. Welcome.
Sorry about that.
No worries, no worries.
Hi, good afternoon, Mr. Chair, Vice Chair, and members of JPR. My name is Maura Dunnigan. I'm the Chief of Staff for Senator Shelley Heddleman, who unfortunately is out sick. She is very disappointed that she cannot join her former committee members for her first hearing before JPR, but rest assured, she is following along virtually. SB 100 passed last year in the Senate 47-0 and passed the House overwhelmingly, only to be vetoed by the governor. It was an important piece of our effort to address a myriad of issues in landlord-tenant law, especially at this time of increased vulnerability for tenants. This bill ensures that landlords comply with local licensing laws before they can evict a tenant using breach of lease and tenant holding over. There is no statutory enforcement mechanism to ensure that landlords are licensed in the jurisdictions that require it before a landlord can use the court system to evict a tenant. In a 2011 case, McDaniel versus Baranowski, the court determined that a landlord is required to be licensed in order to evict someone to failure to pay rent, the most prevalent reason for evicting someone. However, in 2021, the court determined in Balicki versus Copycat that a landlord may seek to evict someone for tenant holding over, even if they are not compliant with local licensing laws. You will soon hear from parties in that case. I want you to keep in mind something that Judge Shirley Watts said in her dissent. This loophole presents an obvious risk of danger to tenants, as unlicensed landlords may now use tenant holding over actions to recover rent and possessions of property and lease the property again, with little incentive to eliminate hazards on the premises and obtain licenses. This bill was carefully crafted to address a landlord's concerns about what they could do if a tenant was at fault. It states clearly that a landlord can evict a tenant if the tenant is responsible for the rental license to be revoked, suspended, or denied when the tenant presents a clear and imminent danger. Moreover, it streamlines the court processes by ensuring that landlords share their licensing information before they use the court system, for they are the best positioned to be able to demonstrate compliance. According to the Maryland Judiciary Case Activity Reports, the eviction rate in Baltimore County is 2 times the state average. Baltimore City's rate is 4 times the state average. State tenant holding over filings are currently 3 times higher than pre-pandemic levels. SB 10 helps to prevent these numbers from rising even higher. Most landlords do comply with these licensing requirements, and they represent a floor, not a ceiling, for basic safety and health standards in housing, and they have nothing to fear from SB 100. Their business practices will not change under this bill. One of government's core duties is to protect citizens, and this bill will help ensure that tenants are protected from bad actors who refuse to comply with local licensing laws, and that measures are in place to protect citizens and families in the statewide and national housing crisis. Thank you.
Thank you, Vice Chair Wallstreicher. Members of the committee, my name is Matt Hill. I'm an attorney at the Public Justice Center.
Matt, for the cameras, do you mind coming to the podium, please?
Oh, of course.
Thank you.
Let's try that again. Good afternoon, Vice Chair Wallstreicher, members of the committee. My name is Matt Hill. I'm an attorney at the Public Justice Center, and we are in support of SB 100. Like any other business, from home improvement contractors to, as Senator West reminded me this morning, cosmetologists, landlords must be licensed in order to use our court system to enforce their rights. But we've had clients, and I know you're going to hear from at least 3 today, we've had many more, where the landlord fails to make repairs, fails to get licensed, and then when the tenant complains, files a tenant holding over eviction case. And this is a legal loophole, as the sponsor just explained, that allows landlords to, at the current state, not be licensed and still move forward with an eviction in rent court. Excuse me, not rent court, but other types of eviction cases like tenant holding over. When landlords can evict tenants without being licensed, there is no incentive for them to become licensed. Now, the context matters here, and I just want to refresh everyone's recollection that in 2022, we made a number of concessions with the Maryland Multi-Housing Association to address their concerns, and this bill passed 47-0 in the Senate. It's my first 47-0 bill. I was very proud of it. But the governor vetoed the bill, and so we're back. And unfortunately, it now appears the landlords are moving the goalposts with new hypothetical situations that they would like to see addressed in the bill. One involves a unit that has a major habitability issue in a larger building, which would stop the landlord from allegedly getting their license renewed. And that's because in some jurisdictions, licensure is by building, not by unit. So I reached out to Jason Hessler, just because I'm most familiar with Baltimore City, and asked, okay, he's the Deputy Commissioner of Housing in Baltimore City. How would you address this if one unit was uninhabitable in this large building that's seeking a renewal of their license? And we're addressing this just today, but he wrote, you know, it could happen, and in those situations, the landlord would need to request an exception, at which point we would amend the license to reflect the number of habitable units until the landlord could bring the unit back online and pass all necessary inspections. I'd love to explain a little bit more about this amendment. We have some significant concerns to what MMHA is proposing, but the point is that the landlord should address this issue with the local agency and not attempt to operate illegally and still move forward with an eviction. Thank you.
Thank you, Mr. Hill. We have some questions, but I think we're going to wait for everyone to testify, if that's okay, on the panel. Whoever would like to go next.
Good afternoon, Senators, Mr. Vice Chair. My name is Gregory Countess. I'm an attorney with the Maryland Legal Aid Bureau. I'm the Director of Advocacy for Housing and Community Development. I wish I could say that this problem is one that only sort of really presented itself during the pandemic, but it is not. I remember in 2017 in Talbot County, where a landlord who owned a mobile home park, he was also landlord for individual trailers, and in those cases, or mobile homes, and in those cases, they would resort, because the person's a tenant, they would resort to the tenant holding over statute. This mobile home park owner was, in fact, cited for by the Maryland Department of the Environment because he had a holding pond to hold waste. And this waste was overflowing the pond, poisoning the park, and poisoning our waterways. And so he decided, instead of taking action to resolve that, to evict all of the tenants who were who rented through the tenant holding over statute. And then one question I would ask in terms of the amendments that are being posed by the folks that represent the industry is, where were they when these licensing laws were put in place? This one bad apple shouldn't spoil the whole bunch, which reminds me of a Michael Jackson song, by the way. And the next line of that song is "Give Me One More Chance." Well, the fact of the matter is that one more chance is reflected in the Baltimore City law, and I would suspect that if that argument had been made, it would be reflected in other laws that have been passed. So there's the nexus. These jurisdictions have decided that the law as it is presented for the purposes of the safety of residents, life, health, and safety for those residents, that those laws would in fact apply or should be or were enforced the way that they are. And so I am. Thank you very much.
Good afternoon. My name is Claudia Wilson Randall. I'm the Executive Director of the Community Development Network of Maryland. We are a statewide network of housing and community development partners, housing counseling agencies, and community-based nonprofits across Maryland. Many of our members, or some of our members, are also property owners and own licensed properties. And many of them are like, hey, this is fine because we're already working within this framework and most of our units are licensed and we don't have any problem with SB 100. I'm here today in support of SB 100. I will say, as the previous speakers spoke about, licensing laws in most municipalities are critical for protecting the health and safety of tenants throughout the state. The number of tenant holding over cases has risen dramatically during the pandemic. Maryland needs to take action to prevent unnecessary evictions throughout the state and keep vulnerable people in the homes they're living in. Also, I would add, landlords have adequate tools to evict any tenant who would hold up repairs or any other breach of lease cases, including provisions permitting them to enter units or any other sorts of provisions that already exist. So the tools are there for landlords to do what they need to do and to operate within the law. And I would just urge your favorable report for SB 100. Thank you very much.
Thank you. We'll take questions. Senator Muse.
Thank you very much, and Mr. Vice Chair, and welcome. I had just a couple of questions for you, Matt. As always, thank you for all the work that you've done down through the years in many areas. Are the local licensing laws all the same, and how many counties have them?
Thanks, Senator. So the local licensing laws are not the same. There are 6 counties that we're aware of that have a licensing law, and quite a number of municipalities. And so the requirements for each of these licensing laws are different. They're done in different ways. So for instance, as I was trying to say, you know, in Baltimore City and a number of other jurisdictions, if you have a larger building, the license is by the building, not by the unit. And so that's a major distinction. And as I look at the amendment that I understand Maryland Multi-Housing Association is proposing, it's amendment number 3, it says, in jurisdictions where multiple rentals are licensed under one license, only the unit or units that are denied, suspended, or revoked under the requirements established in the local jurisdiction shall be deemed unlicensed for purposes of the section. But the problem is there's no indication of a unit being unlicensed or a unit being suspended or revoked. The building is suspended or revoked by the licensing agency. So either MMHA is proposing that these different jurisdictions that would be affected all revise their licensing laws so that they license by unit, which they could, and I guess that's something that, you know, jurisdictions could do. I think that if the state wanted to do that, that would be a different bill. Right. But it's just not workable for a tenant because the judge is looking in there, in a given eviction case, and they're saying, okay, well, which units are denied, suspended, or revoked? And there's no indication. The agency, the housing agency, the city, the county, they're not a party to the eviction case, right? They're the only ones who know which units might have held up an inspection, which one may not have cleared a code violation notice, which one doesn't have a lead certificate or may not have paid a fee. These are all different components of licensure, and it's done by building, not unit. And so I understand the intent, and I really do, but it's just not workable from someone who represents tenants in court, because we're not going to know which units are suspended or revoked, because agencies don't, at least some of them, don't suspend or revoke units. Now, having said that, what the landlord can do is go to the licensing agency. Like I was just saying, reading that email from Mr. Hessler, tell the licensing agency, look, this unit's not inhabitable. I need to take it off my license. Then I can renew my license for the whole building. Perfect, wonderful. We'll do a postponement of the case. Go take care of it. Come back to court. Your license is renewed, and we move forward. That happens right now, frankly. I mean, you can have a licensing issue, a dispute. The landlord goes, there's some administrative error. They get a postponement. They go resolve it. They come back. There's a license, and the judge moves forward with the case. But don't turn these eviction cases into a mini trial about which units are licensed or which ones are not, when the agency is not even there to represent their side of the story.
Thank you. You answered my second question. I wanted to know why you had the opposition to the amendments. I understand that now. Thank you, and thank you, Mr. Chair, Vice Chair.
Thank you.
Thank you.
Thank you, Mr. Chair. So we had this bill last year, as Mr. Hill is well aware, and there are other people in the room who were involved in our conversations last year. And it was controversial, and we arrived at the end of the session, and we'd worked out the bugs on this particular bill, when all of a sudden the multifamily housing folks raised an issue. And they raised the issue because there was a case pending in the then Maryland Court of Appeals. And people got rather agitated. At the end of the day, a new issue was being raised which hadn't been addressed earlier, after the bill had been worked out. So we ended up passing the bill last year, and the governor vetoed it. But in the meantime, over the course of the summer, the Maryland Court of Appeals, then, now the Maryland Supreme Court, issued an opinion in the case of Asana Carroll versus Maher, which has sort of caused this controversy now. So let me ask you, under this particular bill that's proposed, Mr. Hill, the last section of the bill says, at trial, the landlord must demonstrate to the satisfaction of the court that the property listed in the written complaint is licensed with the jurisdiction or is exempt from applicable licensing requirements. So let me give you a hypothetical. In Baltimore City, there's a apartment house on Madison Street. The hypothetical, by the way, are the facts from this decision. An apartment house on Madison Street which has 147 units. And one of those units has a problem and is not habitable. And so the license for the entire apartment house is withdrawn. Then somebody doesn't pay their rent in one of the other units that is habitable, and that person then is taken to court by the landlord, and to try to get the rent. If this language was in effect, at trial, the landlord must demonstrate to the satisfaction of the court that the property listed is licensed. Under my hypothetical, because the license has been withdrawn from the entire apartment building, the landlord would not prevail at trial. In fact, all other 146 tenants in the building could cease paying their rent because of the one uninhabitable unit which has caused the license to be withdrawn, and the landlord could not recover rent from 146 tenants living in units which indeed are habitable and which they're happily inhabiting. Am I not correct?
Well, so again, the owner of this apartment building should have done what the Deputy Commissioner of Housing suggested in his email, which is to change your license, remove the uninhabitable unit from the license, so then you're only licensing 145 units instead of 146, renew your license, and then move forward with a license and operate legally in the jurisdiction, instead of essentially saying, well, I don't want to worry about that unit, I'm just going to go ahead and operate illegally and try to evict tenants anyway. Now, with respect to the Asana Carroll case, which is, I think, the case you're talking about, Senator Smith, that's Senator West, that's the law of the land, in the sense that it says that if a landlord is not licensed, they can't use the court system to collect rent for the period of time in which they were not licensed. That's that's not really this bill. This bill is talking about whether or not the landlord can move forward with an eviction action, even if they're not licensed. So if the General Assembly wants to deal with the Asanda Carroll case, I think you can, but that would be a separate bill. This is really about whether or not a landlord can move forward with an eviction matter if they're not licensed.
Okay, well, let's first of all talk about Mr. Hessler, who, by the way, is an old friend of mine.
Oh, great.
We both served on the Young Lawyers section of the City Bar Association together more years ago than I care to remember. As it happens, I have an email exchange here between Kathy Howard and Kathleen Byrne, who's the Assistant Commissioner for Litigation of the Baltimore City Department of Housing and Community Development, another arm of the city government. And Ms. Howard asked this question: if one unit in a multifamily building has an unresolved code compliance issue, is the entire building deemed unlicensed? The answer was yes, because the license is issued for the entire block/lot, no matter the number of units in the multifamily building. A violation in one unit of a 20-unit apartment building will hold up the issuance of the license for the entire property. So it seems as if there's some divergence of views among people in Baltimore city government as to what would happen in this situation.
I don't think those two things are inconsistent.
Why not?
Because what, as I understand it, that email is talking about is correct in that, under the law, if more than 90 days have passed and a violation notice has not been addressed, then that would hold up licensure for the entire building. Having said that, go address the violation notice. And if you're not going to address the violation notice because it's uninhabitable, you do what Mr. Hessler suggested, which is take the unit off of your license. And then you can get a license for the other 145 units, and that unit's no longer impacting your ability to get or stay licensed.
But in the meantime, under this decision of the Maryland Court of Appeals, the other 146 tenants can stop paying their rent and will never have to pay their rent. When they're sued by the landlord for unpaid rent, they can say, under this decision, we don't have to pay the rent until the license is reissued for the whole building.
A, all the more reason for landlords to get and stay licensed. Then they won't have to deal with that issue. And B, if there is an issue with the way Baltimore City processes licenses, then that should be addressed in Baltimore City, not trying to graft a statewide amendment that doesn't fit within the framework that's been established in each of the 6 counties and the multiple municipalities that have licensing laws.
Okay, well, I'm sure we'll discuss this bill further, but my position is that we need to come up with a way of solving the problem that was recognized and acknowledged under the law. I'm sure the Maryland Court of Appeals correctly interpreted the existing law, but it creates a situation which makes no sense, where 146 tenants can withhold paying rent on units that they're happily occupying because another unit in the same building is unoccupiable. We need to fix that problem, whether as a part of this bill or as a companion bill, which is passed at the same time of this bill, and I'm hoping you're willing to work with us on that.
Happy to discuss further, but I would say that it is a separate issue that is addressed with the Court of Appeals in terms of of obligation to pay rent or not pay rent. And I would just say it's very speculative. I mean, this just doesn't happen in my experience. Nobody says, oh, this landlord's unlicensed, therefore 145 of my neighbors can all just stop paying rent. I mean, tenants just want their building fixed. They want the elevator fixed.
Well, wait a minute.
So that they can get out the door and
You're a lawyer
live their
for
lives.
the tenants. Wouldn't that be your recommendation?
No.
If a tenant's in a building and the
No.
tenant, and the building doesn't have a license, wouldn't you recommend your tenant that they not pay rent?
I would recommend to my tenant that they work with their landlord and address the licensing issue. And if there are, significant conditions of disrepair in the property and they're not satisfied with the property, then, they should work to get the licensing issue addressed or consider moving to another unit where they're not going to deal with the elevator going in and out and the rodent infestation and the lack of heat or whatever else it is that's an issue at the building.
Okay, one final technical question about the bill itself, and then I'll be quiet. On page, I think it's 4 of the bill, lines 21 to 25, it says, in relevant part, on the filing of a written complaint to repossess residential property, ... the landlord shall plead and demonstrate that the property is licensed in compliance with local code. As I read that, that means at the time that the filing is made, the landlord must demonstrate that the property is licensed, which I guess means going to see the court clerk, the filing clerk, and showing evidence that the property is licensed. Is that how you read this language?
So, Senator West, that language, plead and demonstrate, is taken directly from another Court of Appeals opinion called McDaniel v. Baranowski. And in that opinion, this is what said that, landlords have to be licensed to file failure to pay rent cases. They have to plead.
To file.
They have to
file.
plead, this is the phrase used by the court,
Right.
plead and demonstrate licensure in a failure to pay rent matter.
Okay, I
And so
understand
what-
plead. Plead's easy. You write it in the pleading that you file with the court.
That's right, you just
But
write it on the
word
complaint.
demonstrate,
Well,
what
and
does
so-
that mean?
So the way that plays out today in court in rent cases is generally if the court will ask, okay, Mr. Landlord, are you licensed? And they will say, yes, we're licensed. And that is a sufficient demonstration, at least the way it's playing out now, for the landlord, unless they're challenged. So if the tenant comes in and says, well, I don't think they're licensed, and I have this printout from the website to show that, then there's usually something from the landlord where they have to actually show a printed license.
Would you be unhappy if we just deleted the two words "and demonstrate" from this bill? So the landlord has to plead that the landlord is licensed, and then when we get to the trial, that's something else again.
But again, to Senator West, I mean, this is already the law in failure to pay rent cases. And the landlord's already pleading under oath that they are licensed. Again, they testify at the
no
trial they're
problem with the
licensed.
pleading.
And if they're challenged, as we've done, as I've attended, I've stood up there, I said, Your Honor, we did a search on the city's website, and it doesn't look like the landlord's licensed. And then the landlord still has the burden of proof, right?
Wait a
We
minute,
want the landlord to show the
At the
license.
time you file the pleading, there's
Yes.
no judge involved. You're there
Correct.
before the court clerk.
That's the plea, yeah.
Right. So my question, my concern is with the words "and demonstrate." Why would we want to require the landlord to demonstrate at the time of filing?
Okay. Again, it's language from the Court of Appeals, plead and demonstrate, and the way it plays out in rent court is that they, under oath, penalties of perjury, I am licensed, and this is my license number, and that's sufficient to satisfy the court. That's what we're envisioning here.
I get the pleading, I don't get the words "and demonstrate." Thanks.
Demonstrate is for the trial. Thank you.
Okay, thank you.
Not familiar with the licensing issue. I come from a county that doesn't have anything like this. So for me to, you can follow up with me, but in the fiscal note, it only mentioned 3 jurisdictions: Anne Arundel, Prince George's, and Baltimore City. Somebody's testimony said there were 6 in multiple towns, and unfortunately, they're different, you say. There's no, so not to hold up the committee, but I'd like to know the history of why these licensing requirements were in place. I'd like to understand the difference. And also, it seems to me, I'm unclear of whether you're licensing a particular unit or the landlord himself, or does that differ from jurisdiction to jurisdiction? That's the question right there.
Sure.
And I
So,
have a couple others.
so the background, and others should jump in if you feel interested. But the background is
You can make it short here, if you want. If it's going to be a long answer, you can follow up.
I will keep it very short. It's to protect public health and safety. These are in the different counties, and so I know that Montgomery County definitely has a licensure law as well. Baltimore County has a licensure law, but they're to protect public health and safety, mostly by requiring a periodic inspection for threats to life, health, or safety. And so the landlord passes this periodic inspection, they pay a small fee, they get their license. But the laws are different in different jurisdictions. So for instance, in Baltimore County, it's only buildings that are 6 units or less have to be licensed. Whereas in Baltimore, not in Baltimore City anymore, but in Baltimore City now, all units, regardless of single unit or a larger building, have to be licensed. And again, so that varies by jurisdiction, but the underlying goal of each of these licensing laws is to protect public health and safety through that
So as a
inspection.
general matter, you would say that all of the, either whether it's the landlord or the unit itself, when it gets a license, it's warranting to the tenant and the public that the place is habitable. Is that the idea?
Yes.
Okay.
But if I could just follow up on that last point, I mean, I think you raise a really good one. It varies by jurisdiction. Some jurisdiction is by unit. Some jurisdiction is by building. Some applies to certain types of buildings, not other types of buildings. And so that's why it's very difficult for this body to come in with the amendment that MMHA proposes in number 3, saying that it's only the units who are revoked or suspended that are affected, because again, there's just a lot of variation between the different jurisdictions.
What is the penalty when a landlord does not pass the licensure requirement locally? Give me a general, unless they are wildly different as well.
Yeah, so it really depends on, in that respect too. I can speak to Baltimore City because I'm the most familiar with it. So the landlord can be fined, they can be issued a citation. If in really extreme cases, the city agency could actually vacate the building. If there are serious imminent dangers to the tenants in that building. It really varies by jurisdiction, but those are two of the major problems, or excuse me, more major remedies or fines or vacating the building in extreme cases.
And was it ever discussed by any of these jurisdictions when they were creating this licensing program that the thought behind it would be to use it as a defense by a tenant not to get himself evicted for failure to pay rent?
Well, so I can say in Baltimore City, that is a part of the language of the Baltimore City law. It says no landlord shall collect rent, operate the property, retain rent, or do anything related to operating the property. Because what you want to do is disincentivize landlords who may not be caught by the local agency or fined appropriately, but if they can fly under the radar, collect as much rent money as they can, and then if a tenant complains, move forward with an eviction, then no one's going to be licensed. And that's why you're going to hear, I think, from
I'm sorry,
Mako.
can I just interrupt you real quick?
Sure.
Did you just say that in Baltimore City, if the landlord does not have the proper licensing, the law says he's immediately prevented from collecting rent? And if so, then why do you need this law?
Well, because what happens, and you're going to hear from a couple of tenants in a moment, is that there are a number of landlords who are still operating and trying to collect rent. The tenants don't know that the property is not licensed. And so the landlords are extracting as much rent as possible. They're not making repairs to the property. And ultimately, tenants often find out the landlord's not licensed. They'll start complaining about it. And then the landlord says, I'm just going to evict you. We're going to use a tenant holding over action now to evict you. I'm going to bring in another tenant who doesn't know about the licensure. I'm going to take as much rent from them. I'm going to not make repairs. And if they complain, I'll evict them too. So it's a business model and a way for illegally operating landlords to still take in the rent and not invest in the properties, which affects entire communities.
And this is the last thing. I don't want you to take up the committee's time, but I do want any and all of you to let me know whether the discussion around this bill is somehow, the opponents or the proponents, is in any way going to be turned into an argument that this licensing scheme should be around the state, because I would not want this to come up to Hartford County. We have a different way we do business, so I don't know if that's being discussed as an incremental step to try to get all counties to follow along, because suddenly you're going to protect tenants from being evicted, giving them sort of a special right using this licensing procedure, and I just don't know if there's any discussions being had by anybody about trying to expand this whole idea across the state. And you can address that later, but that is a concern of mine.
Well, I can very quickly no. There's no bill that I'm aware of to create a statewide licensing regime. And I would just say that we're really just looking for parity here. Again, home improvement contractors have to be licensed. Cosmetologists have to be licensed. If landlords have to be, and if they want to use the court system, home improvement contractors who enforce what they see as their contract, they have to be licensed, or the court throws it out. And so the same principle should apply to landlords. If they have to be licensed, they should be licensed to use the court system. If they're not, then they shouldn't be able to use the court system.
Well, that wasn't my question, but thank you for that answer. Thank you.
Thank you very much. And I'm not outside of your practicing of landlord-tenant matters. I'm not certain what other type of law you practice, but you might be familiar. If a company doesn't file its annual reports and it's forfeited, are there certain penalties and certain actions that that company can no longer take? Is that accurate?
It is, Senator. I'm going to share the stage, though, if any of my colleagues want to.
And I'm sorry, Senator Sidnor, you're absolutely correct. Though a corporation, at an instance, if they are, if it's forfeited, if their charter is forfeited, can perhaps defend an action, they cannot initiate an action until they get back in good standing and get back their corporate charter. And in many cases, what we find is that a lot of landlords, some landlords, in addition to not being licensed, if they're a chartered entity, are also probably uncharted. There's a lot of, there are among the bad landlords, as I think MMHA says, those that are total scofflaws and operate and tend to operate outside of the law. And that's what we're talking about. And that's why I gave you the example of in Talbot County with mobile home parks. Because there are mobile home parks throughout a lot of jurisdictions throughout this state. And that's perhaps a discussion and a bill for another day. But
So there are consequences civilly, and on the criminal side, there are consequences when the government acts against the Constitution, say obtaining evidence illegally. That evidence can't be entered into court. So these laws are in place to ensure that those actors that are regulated act in a legal way, correct?
that they act lawfully. And, I mean, it's not a principle that was simply discovered back in 2011 in the McDaniels case. It's been in effect for over 100 years.
Thank you very much.
We'll now move on to the next panel. So we've got Anna Levy, Katie Davis, Dominic Lechko from Mako, and then we've got room for one more. So we have Michael Donnelly.
Good afternoon. Thank you, Chair, Vice Chair, and members of the committee. I'm Anna Levy, a resident of District 16 in Rockville, here today on behalf of Jews United for Justice in support of SB 100. JOFJ organizes 6,000 Jews and allies from across Maryland in support of social, racial, and economic justice campaigns. As a member of the statewide coalition Renters United Maryland, we work to advance the rights of all tenants to safe, affordable, and stable housing. Jewish tradition teaches us that we have an obligation to ensure fairness in tenant-landlord law, to ensure safe living conditions, and to prevent homelessness. Access to safe and stable housing has far-reaching economic, health, and social benefits to individuals, families, and communities, and is key to reducing racial inequities. We are taught that a permanent versus temporary home should be sturdy, should not have holes in the roof, and should fully shield a person from the elements. Local rental licensing laws are meant to protect public health and safety, and most landlords comply with those laws. But unlicensed landlords can avoid the law, often refusing to make critical repairs for health and safety hazards while raising rents. SB 100 closes a loophole in Maryland law that allows unlicensed landlords to use the streamlined eviction process to evict tenants for tenant holding over by not renewing their leases. The number of THO filings has tripled since before the pandemic. How many evictions might have been prevented if this bill had been put in place in 2022 when it was passed and then vetoed? How many tenants would be living in safe homes because they were not afraid to report intolerable conditions? No landlord should be incentivized to operate without conforming to the law. On behalf of Jews United for Justice, I thank you for passing this legislation last year and respectfully urge this committee to return a favorable report on SB 100.
Good afternoon. Thank you for the opportunity to testify. I'm Katie Davis, the director of the Pro Bono Resource Center of Maryland's Courtroom Advocacy Project, which has been providing day-of-court legal representation to tenants since 2017. Through this work, we've witnessed firsthand the difficulties and unsafe living conditions that many tenants face and while working to stay housed. We do work in both Baltimore City and Baltimore County, both of which jurisdictions have licensing laws. And I just want to reiterate that this bill is about health and safety for those tenants. So we urge a favorable report on Senate Bill 100 because we believe it will directly affect the lives of these tenants who are facing unsafe living conditions in their homes. It's settled law that unlicensed landlords in jurisdictions that have licensing bills cannot use failure to pay rent. But the issue here to evict tenants when they're unlicensed. The issue is here whether they can use a loophole and use a tenant holding over action to evict tenants. So I wanted to share with you a call that PBRC received on Monday from a tenant, which I think will illuminate some of these issues. We received a call from a tenant who'd been in her home for 4 years, and she told us that for most of that time, she had dealt with dangers to her health in her home. She had water leakage and mold and mildew in the house. She had tried a rent escrow action to put her rent into escrow to incentivize the landlord to fix these issues, but she couldn't do it because the landlord wasn't licensed. Then when she fell behind on rent early in the pandemic, she was denied rental assistance because her landlord wasn't licensed. So this licensure would have been a valid defense to any failure to pay rent action had the landlord brought it, providing incentive for the landlord to get licensed. But this landlord, rather than making the necessary repairs and file the paperwork to become licensed, filed a tenant holding over action, and that's when she called us. This is a real loophole in the law that needs to be fixed. We've seen this in action, and we support Senate Bill 100 to close this loophole. Thank you.
Mr. Chair, members of the committee, Dominic Butchko with the Maryland Association of Counties. MACO supports this bill. This bill does a basic thing. So counties are empowered to enact local rental licensures to protect public health and safety, and we've heard that multiple times in this hearing already. This bill encourages local landlords to be compliant with local regulations, again, to protect local public health and safety. There are amendments being circulated right now. I cannot give you any comments on those because I just received them myself, so I will be running them by our members. But, you know, as our legislative committee currently stands, MACO supports this bill and urges a favorable report. Thank you.
All right. Honorable Chair Smith, members of the committee, my name is Michael Donnelly. I am from Economic Action Maryland. So we're a small nonprofit organization. We do work statewide. We work to advance, economic justice, equity, and inclusion in the economy. And my day-to-day work, I'm going to tell you a little bit about. I speak with tenants on the phone. So basically, I do a lot of triage where there aren't enough resources out there. There are lots of tenants facing eviction, especially in the past 2 years. Since I started in the summer of 2020, there's been a 69% increase in requests for assistance just on eviction. So what that means is last year, that's just shy of 1,400 intake submissions on evictions. And most of the time, when I speak with tenants facing eviction, they're mainly concerned about avoiding it. They don't want their family being displaced. They don't want all of this expense, their property being lost in the process. But when you ask them more questions about what's going on, more often than not, there's serious habitability issues that they're facing. And so while they're trying to avoid an eviction, they are also facing things that would usually qualify for rent escrow. And so I'm here in support of SB 100 because, as has been stated before, this is a common sense way in order to make rental licensing laws effective. Otherwise, landlords can move to evict people through tenant holding over, through other actions, while they themselves are not complying with local laws that are intended to protect people. So for that reason, I'm here to support it. I urge a favorable report, and I respectfully submit my time. Thank you.
Questions from the committee? For Ms. Davis, you mentioned the case you referenced, which the tenant couldn't use the escrow process. What was the name of that case again? Do you have the case or the citation?
No, I don't. This is just a caller who called us this
Oh,
week,
okay,
and
got
this
it.
is what she had told us. Yeah.
So can you explain that again one more time? So she could not put her rent into escrow because the
landlord wasn't licensed, she wasn't able to open an escrow account because it wasn't a licensed landlord. Yeah.
Excellent. Okay, thanks. Seeing no further questions from the committee, thank you all very much. Thank you for your time. Okay, next we'll hear from Antoine Hundell. Indigo Knoll.
Oh, am I supposed to sit right here?
And then do we have Martin Michaels? And then we'll switch panels to the opposition. Whomever would like to go first.
Mr. Chair, members of the committee, thank you for having me. My name is Indigo. I live at the Copycat Building in Baltimore City. I'm going to go off script, actually, because I have submitted written testimony that includes a full code report about conditions in my building and kind of states a little bit about what's been going on. But I wanted to talk about the fact that my landlord has never, to my knowledge, been licensed. I've lived in my building for almost a decade. Conditions have only ever gotten worse. They have not been addressed. We found out at the beginning of the pandemic that because my landlord was unlicensed, we couldn't get rental assistance. And when we could no longer afford to pay our rent because we all lost our jobs, he sent out a threatening letter saying that he would evict us. He planned to use tenant holding over court. We started a tenants union to try to address conditions in the building. And over the next couple of years, I have watched every single person in the tenants union, except for me and my roommates, be evicted. He has also evicted the majority of the people in my building who are part of a long-standing arts community, who are all now gone because they wanted to get him to address the conditions in my building. This includes things like lead, asbestos, power outlets that spray sparks, like serious issues, water coming through the ceiling whenever it rains. And I just want to point out, this is not one unit. This is the whole building. It has been going on for a decade, and he uses a revolving door of evictions to take out anybody who is aware of the lack of licensure in the building. So when we talk about this bill, I want to make it very clear. This is a business practice. This landlord has been using this tenant holding over loophole to extort rental payments from tenants who have to decide between, do I want to be breathing lead or do I want to be homeless? Do I want to live in a building that could burn down at any moment or do I want to be homeless? This is a choice that we've been faced with, and my entire community has been evicted because we tried to get conditions addressed in my building. So please just keep that in mind and see my written testimony.
Good afternoon, Vice President and Senators. My name is Antoine Hutnell. I'm a father of two, and I'm a tenant living in Baltimore City. My family and I lived in our home for 5 years. I have a great relationship with my previous property management company and have always paid my rent on time. However, there was a change in ownership in August 2022, and I had no idea who to pay the rent to. There were two separate people claiming to be the new owners. I have conditions in my home that have yet to be repaired, like the ceiling that is falling down in my basement. I fear for the safety of my children. I did not want to find myself in a scam and lose money by paying rent to the wrong person, and I wanted repairs made. I noticed a number of red flags from the new people that made me feel like I was being scammed. Then out of nowhere, I received to vacate, although I've been trying to figure out who to pay my rent to. Later, I found out that the property was unlicensed, another red flag. License ensured that the owner passes a health and safety inspection and that the real owner of the management is registered with the city. Even though my landlord wasn't licensed, he took me to court in a tenant holdover eviction case, and I lost. The case is on appeal, but I cannot use lack of licensing as a defense to show my landlord's dishonesty. I have been a model tenant for the past 5 years. One of my children has autism, and it's very difficult to move with little notice. The licensing loophole is unjust without passing this bill. Unethical landlords will continue to ignore licensing laws, leaving families like mine unprotected from health and safety hazards and evictions. I urge favorable report of the committee, SB 100. Thank you.
Good afternoon, Chairman Smith, Vice Chair, members of the committee. Thank you for the opportunity to speak before you today. My name is Martin Michaels. I am a Housing Legal Fellow at CASA. CASA is the largest member-led immigrant rights organization in the state of Maryland, and this bill is of paramount importance to our 122,000 members, most of whom are Black and Latino residents across Maryland and the Mid-Atlantic region. CASA is strongly in favor of SB 100 and asks for a favorable report. Not to beat a dead horse here, but unlicensed landlords should not use our court system to carry out evictions. And yet, at CASA Legal, that's something, unfortunately, we see every day. We just heard from Antoine and Indigo. I work with clients every day who complain about very serious eviction issues, rat infestations, mold, and so forth. At a minimum, licensing exists to ensure that residents are safe and habitable for the tenants. It's not a trivial matter. It's not bureaucracy for bureaucracy's sake. Licensing is significant and it matters. It's necessary oversight. Currently, as we've heard from others who have testified, there is a loophole in our case law. SB 100 would close that loophole. It would provide for these essential protections and oversight, and it would prevent landlords from evicting tenants in tenant holding over actions. SB 100 is an opportunity, as I said, to strengthen those protections, improve housing stability, and promote judicial economy and fairness in our courts. I urge you to return a favorable report for SB 100, and I thank you for your time.
Thank you, Mr. Chair. Just briefly, the First Lady, could I talk to you for a moment? Could you go back to the podium? So I don't want my concern about this bill to be interpreted as suggesting that I want to protect bad landlords. Seems to me the good landlords ought to be able to conduct their business in a normal business-like fashion. The bad landlord should be called to account. So it sounds like you're in a building with a bad landlord. What is the address of your building and what is the name of the landlord?
I live at the Copycat Building. It's at 1511 Guilford Avenue in Baltimore City, and the landlord's name is Charles Langford.
Okay. How long have you lived there?
I have lived there since 2015.
Oh, so about 8 years?
Actually longer. I was living there in another place for a while before too,
Okay.
so.
Are your rental payments up to date?
They were up to date until the beginning of the pandemic, yes.
So you haven't paid rent since the beginning of the pandemic?
I was advised to stop paying rent.
How much unpaid rent do you owe the landlord at this point?
I don't owe him anything because he's unlicensed.
But if you added up all the unpaid rental payments between when you stopped paying rent and today, how much would they add up to?
That's honestly a good question, because part of the problem at the Copycat is that they don't keep very good books. And so we're not even sure what they're charging on my unit for rent sometimes.
Well, what under your lease, what would you have paid if you had paid your rental payments?
I was not given a paper lease when I moved into my unit.
Really?
That is also part of the problem.
So you have no idea what rent you're obligated to pay?
I know that for a long time I was paying, just for my bedroom, $450 to $550 a month. It's hard to tell other than that because there's been a revolving door of tenants around me.
Around you or in your unit?
In my unit.
Oh, okay. So you have your own arrangements with the other tenants in your unit as to who's going to pay what portion of the rent? What's the rent for the whole unit on a monthly basis?
That depends. If you look in our online pay portal, it says one amount. It says $28.90, but if you ask the landlord and look at emails we have, it says $27.50.
Okay. So it's around, $2,800, give or take. And you haven't paid it since the beginning of the pandemic, so that's 2020. So basically 3 years of unpaid rent?
I do want to point out that we have several times tried to talk to my landlord to make a deal about him fixing certain issues, like my refrigerator stopped working in the week of Thanksgiving in 2021, and he has refused to replace it since. We've asked him to fix issues with water pressure because we were flushing our toilet with a bucket for a long time. Every time we've reached out to him and said, we want to pay you rent, but we need a working refrigerator, we need a working toilet, we need these things, he has literally refused to respond. We won our last tenant holding over case with him, and again reached out to him this year and said, we would really like to pay you rent. Will you please come to the table and fix these issues in our unit? And again, he did not respond, and instead he filed another tenant holding over case against me, even though he lost the last one.
Did you put the money into escrow?
We were told that we couldn't because he's unlicensed.
Interesting. Okay. Thanks. That's helpful.
Seeing no further questions from the committee, thank you all very much. Thank you for your time. All right, we'll now switch to the opposition panel, and we'll have, oh, sorry, my apologies, favorable with amendments. We'll start off with Mr. Greenfield, Aaron Greenfield, Ryan Washington, Grayson Wiggins, and Catherine Howard.
Good afternoon, Mr. Chairman, members of the committee. Aaron Greenfield here on behalf of the Maryland Multi-Housing Association. We are favorable with amendments. You've heard a lot about our amendments. We're here to, let me be clear, we aren't here to oppose the licensing of rental units and the consequences of an unlicensed housing provider to repossess that unit. Our issue is very simple. It's very, very simple. We want to make sure that this bill works at these 6 local jurisdictions, local licensing regimes. To answer Senator James' question, in all jurisdictions we're aware of, one property is licensed with multiple units. And so it makes the repossession of one that does not cause the license to be out of compliance, it makes the landlord unable to repossess that property and collect rent, as you've heard. Let me talk quickly of my two amendments. The first one is the fact that our members routinely encounter local licensing systems that lapse, are offline, or change their requirements. Baltimore City, their local licensing system was offline for 4 months, which meant renewals didn't happen, which meant there were unlicensed landlords. Anne Arundel County enforced suddenly a new requirement or an existing requirement they started enforcing with respect to UNO occupancies. Our members had to go back to find documents 40 or 50 years old. This happens. We're not angry about it, it happens. But we're trying to work within the system. And so when those lapses occur, we shouldn't be held responsible. And then secondly, you've heard over and over again about the multiple units on one license. Senator West brought up Ms. Burns' email, which hit it right on the head. If you have 20 units on one license and one unit is in violation, the housing provider is prevented from repossessing any other unit that is compliant. So our suggested amendment makes clear that that common scenario is addressed and just that specific unit that is out of compliance cannot be repossessed. Thank you. For those reasons, we're favorable with amendments.
Good afternoon. My name is Kathy Howard. I'm General Counsel for Regional Management, Inc. Regional Management, Inc. is a founding member of the Maryland Multi-Housing Association, and as my testimony indicates, we are in favor of the amendments that Aaron has indicated is our position. I just want to talk really quickly about regional management and the testimony that I put in. The regional management has been in business for 60 years. We are, I think, a very good landlord in Baltimore City and Baltimore County. In my testimony, you will see first a plat at the College Gardens Corporation area. And it has 83 units on it. There is one that that was out of compliance. We had a violation notice from Baltimore City. We fixed it, and then we had to wait for an abatement inspection. It took 2.5 months to get that abatement inspection. All that time that we are determined to be under the licensing scheme in Baltimore City to be non-compliant. That means that the entire 82 units plus the 83rd unit are out of compliance. Mr. Hill has apparently talked to Mr. Hessler, who is a mutual friend of Senator West's and mine, and he's decided that there should be an exception made for that one unit. This is a townhouse community. I don't know how I exempt or accept the one unit that is part of the entire plat. That is Ms. Burns, who is now in Montgomery County, was absolutely certain when she made that statement that it is the entire plat that becomes unlicensed. I will sum up by saying the other problem is that in Baltimore City in particular, you have problems with the systems working. They're in the process of getting a new vendor. And unfortunately, we have had units, we have had plats where we have paid for all 200 and some plats. We have licenses for 90 some of those plats, but the rest of them are still not done. This makes us non-compliant, and this is a real problem in some of these areas. This bill and our amendment would make sure that this would not prevent regional management from collecting its rent from people who owe the money and are good tenants, and we should not have to be under this particular issue without this amendment. And I would urge a favorable report for the amendment and for the bill. Thank you.
Good afternoon. Can you all hear me? Sorry. My name is Ryan Washington. I represent the Apartment Office Building Association, also known as AOBA. We represent about 133,000 rental units throughout Montgomery and Prince George's County. We support the amendments that MMHA brought, and we're favorable with the amendments. I would just like to highlight regarding the rental licensing issue that's just been brought up throughout the debate. I've worked with a lot of properties in the county where they've experienced delays in getting their license renewed due to the department rescheduling inspections, particularly it may be a fire inspection. That's not the fault of the housing provider. These amendments that are proposed really do help provide that flexibility and clarity for our members. And we support them, and we're in the interest of providing housing, safe housing for our members. And a lot of these issues aren't due to just habitability, but it could be administrative and governmental issues. And with that, I'll be posted for any questions. Thank you.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins on behalf of the Maryland Multi-Housing Association. You heard a little bit about the amendments. I want to talk a little bit about what the proponents just said. So you heard a little bit talk about the THO loophole, the tenant holding over loophole. That's actually been used by them for the last couple of years. There is testimony from 2021 where the THO loophole was attributed to the eviction moratoria. Mr. Chair, it was actually on your bill from 2 years ago where licensing was never mentioned or attributed to the THO loophole. It's just this continued talking point that they use consistently to push bills. So what is a THO? It's important to talk about that. THO occurs when the tenant refuses to leave the property after the lease has ended. So the landlord has given notice to the tenant, 90 days on a year-long lease, 60 days on a month-to-month. We actually just extended that 2 years ago in this committee with Senator Carter's bill. And so the landlord has notified the tenant that they're not going to renew the lease. The tenant refuses to leave. They continue to stay in the property, effectively squatting in it, if we're being candid. And so at that point, you can file a THO. This concept that it's a replacement for a failure to pay rent case is candidly a bit absurd in my mind. What we're seeing, and you'll remember last year when I brought in cases where tenants were starting a lease, not paying rent for a full year, and not getting a hearing until after the lease had ended, well beyond the lease ending in some cases. And I think in some situations, the landlord who had not been paid in over a year was probably trying to find a way to continue to operate, and so they filed a THO because, again, the lease at that point had ended and the tenant was refusing to leave. They're still in the property. I want to note on one unit on multiple units and one unit holding up multiple units, if you look at the bill, page 4, lines 10 through 13, there's an exception if the tenant causes the issue. So, and I'll summarize, I'll finish up here, Mr. Chair. So again, page 4, lines 10 through 13. So if a tenant in unit 1 causes the loss of a license, which this bill recognizes does happen because they have an exception, the landlord has an exception for that one tenant who caused the issue in unit 1, but there's no exception for the other 99 tenants. And so we can't collect rent. We can't enforce our lease. We can't bring a breach of lease. If another tenant down the hall has breached their lease, that's going to impact your constituency. The people who are living in these properties, they're going to come to us and they're going to say, my neighbor isn't abiding by their lease and they're causing me heartache and headaches. Can you do anything? And we're going to have to tell them if this bill passes, well, another tenant down the hall caused an issue and we're trying to deal with them first. We cannot enforce our lease on this other tenant. That's a very serious situation, not only for us, but for your constituents who live in the property. Thank you.
All right, Senator West.
Thank you, Mr. Chair. Let me ask, let's see, Mr. Wiggins, I'll ask you. Mr. Hill, during his testimony, suggested that the way to solve this would be for the landlord community to go to each of the counties which have licensing regimes and each of the municipalities which have licensing regimes and get them to change their licensing regimes in order to deal with this issue, the issue of one out-of-compliant tenant in a multifamily apartment house. Is that a realistic way to solve the problem, in your view?
I don't think it is, because what this bill does is it's attempting to graft this overarching change to all these jurisdictions with different requirements or different mechanisms in place and processes in place. If you were to pass this law with that idea of just go to the local jurisdictions and have them change it, you'd be knowingly passing this law with I'm going to call it a loophole, right? Because that's what the bill creates. It creates a loophole where we can't enforce a lease because of the actions of a tenant or because of the actions of a city. And we see that, right? So give you an example. We've seen this, and I'm going to take us a little far. I'll bring us back. In Baltimore City, for example, we had a landlord who just this past year, their license was non-renewed because the city's system, for some reason, unbeknownst to us, maybe unbeknownst to the city, connected a code violation from 2009 to the property just this year for high grass and weeds. And so the landlord couldn't get their license on time and actually was forced to operate during a time without a license because of a code violation from 2009 for high grass and weeds. This is not unique. It actually happened twice, both for high grass and weeds. And then there was another one in 2007 that held up a license because of rear yard animal waste. So 14 years later, it's holding up a license. And if you pass this bill, the situations that we described will become reality, especially, and to your point, under the Asana Carroll case, which recently changed it so that now tenants can just live rent-free.
So let me ask one final question. If we form a work group in the committee to try to come to a conclusion on this and reach a consensus, either through an amendment to this bill or in a companion bill which would be passed at the same time as this bill, would you all be willing to work with us to achieve that consensus?
Absolutely. That's what we're here trying to do today. We have amendments. We are trying to solve this issue. I think Aaron covered that. The intent is to try and make this a workable bill and to solve the issues and the loopholes that we're pointing out.
Thank you very much.
From the committee? All right, Senator Sidnor.
Just one point, just for clarification. You're in the bill's current format, you're saying that a landlord will be held accountable. It's essentially no fault, so government doesn't do what it needs to do in a timely fashion, then the landlord will be held accountable, although they've done what they needed to do and filed for their license in a timely manner?
That's our understanding, yes. If that's not your understanding, I would suggest we just put an amendment in for that right now, and then we talk about the other issues next week or whenever you want to have the work group.
Thank you.
All right, seeing no further questions from the committee, thank you all very much. We'll now switch we have several remote witnesses, and we will start with Wesley Stewart. We'll go Natasha Smith, Gwen DuBois. They're all here? They're not all in yet. All right. Mr. Stewart, you're up.
Yes, good afternoon, Mr. Chairman, members of the committee. This is Wes Stewart from Green and Healthy Homes Initiative. GHHI is here in support of SB 100. We're a nonprofit organization that provides tenants' rights assistance, legal representation for hazard repair, and also compliance assistance for rental property owners. From our standpoint, it's really a basic clean hands concept that in jurisdictions that require landlord licensing, those owners should come to court being in compliance with the local laws in order to use the state-sanctioned district court process. In addition, from a practical matter, many jurisdictions have challenges in identifying rental properties in their jurisdiction, but at some point, most of those owners come before the district court, rent court. And as a mechanism to increase compliance, we support SB 100 as well, as it will increase compliance rates with landlord licensing, improve housing code compliance, and also lead inspection compliance rates under the Maryland Reduction of Lead Risk in Housing Law. So for those reasons, we are here today and ask for a favorable report on SB 100. Thank you.
Thank you. Any questions for this witness? All right, if not, we'll queue up the next witness. Okay, Tasha 18.
Good afternoon, and thank you for the opportunity to speak before you today. My name is Tasha Etienne, and I am a regional property manager with the CT Group. And we are in favor of the bill with the amendment. A large portion of our portfolio consists of affordable housing communities, and our experience in Baltimore City, where licenses are issued in bulk, is, like many of the others have said, a problem in one unit can. Thank you for the opportunity to speak before you today. My name is Tasha Etienne, and I am a regional property manager. I'm sorry, can you all hear me? So the problem is that a problem in one unit can prevent a license from being issued for all of the units. And we recently had an instance similar to what Grayson or Mr. Wiggins mentioned, where we learned of a code violation when we went to renew the license. And it took a couple months for that to be resolved. A large portion of our portfolio we manage for HUD, and we are required by those agreements that we have with HUD to pursue legal cases against tenants who are in violation of their lease. And as the bill is written as it is, we would not be able to effectively, or we would not be in compliance with we would be out of compliance not only with the Maryland law, but with our agreement with HUD should the bill pass as it is written. Thank you for your time.
Let's wait for Ms. Scott to connect.
She's still connecting.
To give us a little bit of indulgence here, this is our first time experimenting with the hybrid system, so we're having, Ms. Scott is having a little bit of difficulty connecting. We'll wait a couple more seconds and then unfortunately we'll have to move on. All right. Unfortunately, she's unable to, our next witness is unable to connect, so we're going to move on to the next bill. And with that, that'll conclude the hearing for Senate Bill 100. Thank you all to the panelists and the witnesses that came today. Thanks for sticking in there with us. We'll now move on to Senate Bill 123, if Senator Ellis is here. Senator Sidnor, are you ready to go? If not, all right. We'll go ahead and go on to Senator Sidnor, Senate Bill 11.
All right, good afternoon, Mr. Chair and committee. This bill, Senate Bill 11, was introduced and I thought was going to be a really simple bill, but ended up being a little bit more complicated than I intended. Many times when we deal with speed cameras and the like, it garners an awful lot of attention. Last year, upon traveling, I had began noting that some speed cameras were set up in ways that I kind of questioned. Last fall, we had some accidents in Baltimore City around schools where people were injured. I took an opportunity to look at the school zone camera law because some of the placements, the way the law is, there's a school zone. School zones, it's a radius a half a mile around the school. And given some of the accidents that I began seeing and hearing about, I just began to question why a radius would be so large and having cameras set up at such a distance from a school if the cameras were truly about ensuring that the children that were walking to the schools were safe. So initially I put in a bill to adjust the boundaries from a half a mile to like a tenth of a mile. I had a conversation with State Highways last week, and they noted some of the concerns in modifying the distance or the radius of the school zone, and pointed to some of its policy that it has that it is actually on the State Highways site. So in looking at State Highways policies, they actually have a little bit of a different, or they have rules that are not necessarily followed by this particular jurisdiction that I'm talking about. I handed out to you all copies. These are, I guess, Google Maps forms that I printed out. So you have one camera at the top of the form that I handed out with school zone cameras placed on West University Parkway right next to Johns Hopkins University. The following picture is a picture of US Route 40, which is in Baltimore City. And there are cameras that are placed, and right in the middle is a bridge. That was the camera that actually caught my attention because I reached out to Baltimore City's Transportation Department to inquire which school was near these cameras. And the reality is, I believe that some of our jurisdictions, rather than using school zone cameras to protect children, they're set up in such a ways when you have neighbors or community members who they want speed cameras, so they use the law, and since you give them up to a half mile, they use up to a half mile, not necessarily considering what's happening with schools and children walking across the streets, because I can tell you, in all the years that I've lived in this area, I've never seen school children walking across US Route 40 to go to school. So, again, in talking with state highways, they expressed some concern with the initial bill as drafted because they said that a number of jurisdictions, what they do, because they've already relied on the half a mile, if the bill were to go in and shrink the radius, there could be cameras that would be out of compliance and it would cause a lot of issues. But they pointed to their regulations online or their policy. So what I did, we submitted an amendment that you all have, essentially looking to codify state highways rules. Now, for whatever reason, and I can't say that I'm exactly certain why, but for the most part, if your county has school zone cameras, they already follow these particular policies because state highways is involved. There's one jurisdiction that doesn't follow this, that's Baltimore City. They kind of do what they do. If you were to look at the, if you even were to look at the definition of, and I'm talking about current law when we're talking about school zones, it's about K through 12. And if it's about K through 12, the question that I've had is why are school zone cameras sitting next to Johns Hopkins University? It's not a K through 12 school. And there are other instances and the like. So essentially that's what this bill is about. It's about making certain when you have a decrease in crossing guards and you have accidents happening around schools, it's about trying to make certain that we're using school zone cameras effectively to make certain that children and families and crossing guards are safe. So that's the essence of the bill. And you know what I did, because I was curious about the radius and why it was a half mile. So I thought that maybe when we started having speed cameras that was built into that somehow. I reached out to legislative services and in fact, that half mile radius had nothing at all to do with speed cameras. It goes back to 1957 when there was a big to-do about jurisdictions being able to modify or regulate the speed around schools. So they gave them local jurisdictions that kind of latitude to control the speeds around schools. It had nothing to do with school zone cameras. So I put that out there because it was a question that I had, and I thought it was something that you all might find interesting. So with that, I rest, and if you have any questions, I'm more than happy to answer.
Mr. Chairman, and thank you, Senator, for bringing this bill up. You know, even in the rural areas, we've got issues that I believe it's too broad. People that live in those communities and that kind of stuff, they know where their schools are. And it's important that they don't speed where the school is. But I've got a particular jurisdiction of mine that it's encompassed the whole town. And even people getting off tourism and that kind of stuff, they don't know that, even though if they saw a school and knew the sign was there, it's something different. So I was wondering if you could maybe touch upon why you think there's so many people in opposition.
You know, I can only posit they looked at the last bill and they didn't like the fact that the zone was being decreased. I don't think that they would be in, I don't know if they'd be in opposition to this because, again, if state highways is involved, this is how your cameras are set up. So really, all the cameras where state highways has been involved, they should be in compliance with what I'm trying to do with this particular legislation.
It sounds like that with this amendment, we're just trying to codify what is already in practice.
Yes, sir.
And making it fair and balanced for
Across
everybody.
the entire state.
And I think the governor said something about not leave anybody behind. Isn't that so?
Isn't that so? Yes, sir.
Thank you, Mr. Chair. So I'm looking at your amendment, and I just want to be clear.
how does this change from what your original design is, where it was going to be a half mile? And just in lay terms, like, what's the difference between it is now at a half mile, and here it says, I see that it's like, may not exceed 500 feet approaching or beyond the school building or school grounds. So it's still going to require, if I'm reading this correctly, it doesn't matter, the half mile is irrelevant because it still talks about, it's still got to be within 500 feet of the school, which it still brings it down. Actually, it makes it less than a tenth of a mile, because a tenth of a mile would be 528 feet.
Right, which is interesting, or counterintuitive. What this does is it brings consistency across the board, having the state highway administration, it involves them. So if you're looking to go beyond whatever they have that's reasonable, I think you now have a traffic study or whatever that's involved, so.
Okay. So, they have to do a traffic
It's
study.
currently so this, again, it's current state policy. Why we have a jurisdiction that operates outside of what I think is plain, I don't know.
I mean, I like it. I think it's always been a money grab, a lot of it. I mean, the one on 40, I drive by it every day. I go to work in Baltimore.
Do you wonder where the school is?
It's all the way up the hill, way up further. It's the one across from where the students were shot at the Popeyes. That's how far that school is away, right?
There's Wildwood, which is one of the schools, but again, that goes beyond a half mile. And the city gave me another school, which was just at about a half mile, but again, it's nowhere near where this camera is.
It's that western. It's western.
You're thinking of West Side Skills, but it's not Edmondson.
No?
It's an elementary school, and I think it's Rodman, but it's slipping my mind at the moment.
But this, I mean, I agree. I like seeing you come in here with a common sense application. I wish you the best. I don't know but this is, the legislation, I mean, so, one last thing. For the existing schools that have them under the half-mile radius, but not within 500 feet, would this require them to redo a study and move them if necessary?
I would have to check with State House. It may.
I'm okay with it because
it may.
it's not paid for by the municipality anyways.
Right.
It's paid, it has to
Not
be
State
moved by
Highways.
the people, not even State Highway. It's paid for by the company that sets the cameras up because they get a percentage of all those tickets.
Correct.
Which is a problem in and of itself, the way it's designed. It's a money grab. So, isn't that correct, sir? Thank you.
Thank you, Mr. Chairman. Actually, I'm intrigued because the first picture of University Parkway, I was wondering what school would be within half a mile of this, and I know the answer.
What?
The name is Calvert School. It's a small private school
Thank you very
located
much.
in the Tuscany, Canterbury area. I attended Calvert School until I was 12 years old. So I know the school really well. And not in the memory of human beings has any student in Calvert School, who are all under
across
12 years old,
University?
walked along University Parkway. It has never happened. Also, there's one that's been set up on Lake Avenue. I lived a half a block off Lake Avenue for most of my developing life. That's set up because Bryn Mawr School is within a half a mile. And I have driven Lake Avenue my entire life. I have never once seen a Bryn Mawr student walking along Lake Avenue. It's a money grab. Thank you.
I believe that the decisions that are made with regards to the way these cameras or these school zones are set up, I would question whether or not the school system even has any input in it. So, I mean, and at one point, I even thought of putting that in the bill to make certain that the school system, maybe it was something, a question or request that they would have, but I did not put that in here. But certainly one would think that schools would have some input in determining whether or not they want to be school zones and need these cameras, so. And again, this is not a bill to stop cameras from being used. It's one to make certain that we're using the cameras effectively to protect our children. No other questions?
From the committee? All right, excellent. Thank you very much, Senator.
Thank you.
All right, we'll now switch to the opposition panel, which may change. I don't know. We'll see. Mr. Carrington, Ms. Sample, Mr. George, and, got it.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. This is my first time before you in many years, I guess, due to COVID. It is always wonderful to be here before you, Mr. Chairman. Welcome back, Senator Muse from Prince George's County. I'd like to first start out by saying when I found out I have to go in opposition to a bill that's being presented by Mr. Signer, I almost broke down and cried. He is without a doubt one of the nicest, thoughtful people that we have in this body, and so my apologies for having to stand here and oppose your bill. But I am here to oppose this bill, and I'm here to oppose it loudly. No, look, in all seriousnly, you have my written testimony. You also have the attachment I gave you from the Department of Health and Mental Hygiene, while the esteemed gentleman from Baltimore County, Senator, are we allowed to use names here, sir? Senator West had his comments, I would disagree. This is about saving lives. I'm here on behalf of Census Gatso USA, and for the record, my name is Darrell Carrington, Carrington and Associates LLC, and we are here on behalf of Census Gatso, the leading group for traffic enforcement in the world. We're in over 70 countries. We've been around for over 60 years. We are the ones in 1997 that started and worked with the Swedish government to come up with Vision Zero. Vision Zero has been adopted around the world, including in Maryland, Montgomery County, Prince George's County, and others. With that program, we've saved over 500,000 lives in Sweden. We've also saved an incredible amount of lives here in the United States. I cannot quantify that for you, but we will get you that information. I think that I always learn something when I come here, and today I learned that even in the 50s, we realized that we needed to have specific policy around our schools with regard to safety. It's about public safety. If you look at the information that we share with you, teen deaths, the number one cause for teen deaths by 2030 is going to be traffic related. We have people getting hit when they're coming out of their cars to get their children out in the morning. This isn't about a money grab because, as a matter of fact, what we do is we see the number actually in terms of revenue, it declines as behaviors change, and that's exactly what we want to see. We want to see our revenues go down over time because there will be behavior change. And so we have to use a stick sometimes, as the great gentleman from Western Maryland just said, but we have to make sure that we are confronting a major issue. We have all seen the donuts being done in Silver Spring, Mr. Chairman, right there at Spring Street. I'm sure you shop in that area sometimes. There are kids there, and they're doing donuts in the middle of the streets. Since COVID, people have lost their minds. We have exhibition racing. We have like our law enforcement folks cannot keep up with these moving, roving racing contests. So we are doing everything we can to try to slow drivers down, to change behaviors, and to eliminate this reckless behavior. So that's why we're here in opposition. Now, of course, we'll be more than happy to work with the sponsor to try to work on amendments and the like, but we think this is a bad approach. It sends a bad message to the motoring public, and we thank you for your time, and we ask for an unfavorable report. Thank you.
Thank you very much.
All right, good afternoon, everyone. Thank you to the chair and thank you to the members of the committee. I am Sarah Sample, and I am here on behalf of the Maryland Association of Counties, and I am testifying in opposition of Senate Bill 11. So we've got two major concerns with this bill. One is, obviously, like we've talked about, it would shrink the radius from a half-mile radius around a school to a 0.1-mile radius around a school. And so there's a fiscal burden that would come to the counties that would be having to disassemble and deconstruct, in some situations, the traffic easing mechanisms that are in place currently. So this is signs and the cameras. This could even be actual roadway construction that would need to be adjusted. We had gotten some estimates from a few counties, and I think one county that I had heard back from, it was 214 different locations. And I think it was almost about $1 million that it would cost them to make the adjustments. But I would actually, from the fiscal standpoint, I would point you to the fiscal note. I think that does a pretty good job of detailing some of the fiscal impacts on the counties when it would come to implementing this change. But I think maybe even more importantly, our second major concern is really the safety of these areas. You know, these are areas where there's going to be a lot more pedestrian traffic, especially kids. And the other thing to remember is that Typically, school bus service doesn't happen. It's not provided inside the school zone. So this is where you have kids who are going to be walking, they're biking, scootering, whatever the mechanism is that they're trying to get to school. These are the areas where that is meant to happen because there is no school bus service typically in these areas. Recently, we've been seeing that there is a school bus shortage. And so the first communities that are going to lose school bus service with the shortage is going to be communities that are closest to the school zone, so adjacent to the school zone. So we would essentially be shrinking this radius at a time when the need for safety in these areas is actually expanding. So for that reason, we would oppose Senate Bill 11. Thank you.
Good afternoon, Chair Smith and members of the committee. My name is Bill Jorsch with the Maryland Municipal League, here today in opposition to Senate Bill 11. I don't want to reiterate much of what my colleagues have said before me on the opposition, but I do want to talk just like a little bit about kind of what the school zone does in addition. There's been a lot of talk about the speed camera aspect to it, but one important aspect of the school zone designation is that local governments are then able to lower the speed limit lower in school zones than on other roads in the surrounding areas. So that's a key component. So while the discussion may be focused on speed cameras, keep in mind that by shrinking the school zone radius, you're also limiting the area in which we can reduce the speed limit as well, which Senator Sidnor touched on briefly in his presentation. So I had to dig back into my high school algebra and geometry, so bear with me for a minute. But so if by reducing the radius from half a mile to a tenth of a mile, that is a 25 times reduction in the area that would be covered by a school zone. Not 25%, but 25 times. A car traveling at 20 miles an hour can travel half a mile in a minute and a half. A car traveling 20 miles an hour can travel 1/10 of a mile in 18 seconds. It is a giant difference. And I know that there are proposed amendments from the sponsor, and unfortunately, I don't have them, so I'm reticent to comment on them. But again, happy to work with the senator and the committee on any sort of compromise. But I just wanted to bring to the attention to the committee that there's more than just speed cameras when it comes to school zone authority for local governments. We ask for an unfavorable report on the bill as written.
Excellent. Senator Folden.
I'm sorry, are we able to ask anybody on the panel? Okay, thank you, Mr. Chairman. First, I just wanted to start off by Mr. Carrington. I'm really, really upset that I was not included in your whole monologue about everybody else being included, how grateful you are to see them, and I was never.
I was going to go with Go Eagles, but I didn't know if I was allowed.
Apology as being at least in the top nicest group. Having said that, I'm just curious because you represent the vendors. What is
vendor?
A large vendor. What is the percentage? What is the percentage of monies by citation that goes back to the vending company by contract, on average?
Let's just say ballpark figuring it, let's say it's about 60-40 to the municipality or the.
So the vendor comes in, sets up the equipment, they move it like Mako referenced, they set it up, they do whatever, and from that point forward, 40% goes to the vendor because they set up this great camera and service for free, 60% goes to the municipality or government entity, correct?
That sounds like a really good deal. So, yes, sir, that is correct.
I know it sounds like a really good deal because it's a great deal for the person that's not there doing anything but setting it up. All right.
Well, Senator, if you would allow that, with that comes, in all seriousness, we come in, we install the equipment, and these cameras are quite pricey, as you can imagine. But not only that, but it's all the back end stuff. So when I'm speaking with a town administrator, I say at the end of the day, when you're working with Census Gatso, your town administrator will get a check every month, and we do everything else for you. So we handle the back end. When your residents complain about getting a ticket, Darrell Carrington will come to your town hall and let your residents yell at me about their speed camera tickets.
That's not altogether accurate, though, because you still have a police department that if someone disputes this, has to have someone in place that's paid to send out the notices, to verify, and then to show up in court to show that the system was calibrated and all the proper workings, right?
Well, when
Or
you're
do you
working
do
with
that?
census gases, we have like 98% success rate, so this doesn't happen to us as often as it may happen to other vendors. I can't speak for other
But I'm
vendors.
saying you still have to have somebody there that verifies the process. Like
And
state
right,
police
you-
has somebody.
You literally have somebody sit in front of a camera and click a button. I mean, like,
I'm
I
not
could
talking about
train
that
it.
guy. I'm not talking about that guy. I'm talking about, there is somebody that sits along the highway. I'm talking about that once they're issued and someone wants to contest the citation.
Correct.
There is someone within the individual police department that issued the citation that has to review it, has to catalog it, and has to show up to court if the person decides to dispute it.
That is correct.
Okay. So it's not totally done free. Like, there's still
Well,
somebody
no,
that has to
it's not
monitor.
done free at all, Senator. I think that's fair. We certainly receive a
Okay.
fee for our services.
And then, I just want to clarify, so on the half-mile radius, and this, ma'am, I'm sorry for Mako, I don't.
No, Sarah, sample.
Sarah, so as far as Mako is concerned, I just find it interesting, like Senator Sidnor pointed out, you know, you have this camera on Old National Pike there on 40, right? And then you don't have a school, you have a school somewhere within a half-mile radius. It could be in any direction. Fair?
Fair.
And because of that, isn't it also fair to say, if this is truly about safety of children, that we would have it closer to the school, because that's where we want to slow them down? Because when I go across past that speed camera that's at the bridge at 40, I know, and it's a great spot. Somehow they always end up on like hills. It's crazy. So I'm going down this decline onto a bridge. So I'm at my fastest point coming down the hill, and then I start back up. But as I start back up, I'm on the other side of the bridge, and I'm also out of the view of the camera. So I can increase by speed again and actually be going through the school zone itself where the school actually is much faster without any penalty unless there's a physical human being there. Isn't that?
I don't know if that is correct. I don't. I mean, that would depend upon, if you'll allow me, that depends upon me actually understanding and knowing that particular driver and what they're thinking of. What I would say is this, is that when we're looking at a half-a-mile radius around the school, we want to change the behaviors of everybody in that entire zone. I don't want anyone to get into a traffic accident in that zone. I want people to know that if I'm traveling fast, I don't know exactly where all the cameras may be, so I have to control my speed. I know I personally have slowed down after getting some of these traffic tickets, and I'm just more careful, and that's what we want people to do, is in that entire zone. I would like them to change that behavior.
But it's not for the entire zone. It's meant to affect the change to protect children, and the concentration of children is around the immediate area of the school zone.
Well, they also live in the neighborhoods
They
surrounding.
do live in the
and all that.
neighborhoods.
But
and they
I should let my
disperse.
colleague
But
from
a lot of them
Mako speak as
go
well.
on school buses. if they
Nothing,
live-
nothing gets the blood pumping like speed cameras here. But
It's a good topic, Mr. Chairman.
I know. Yeah, let's.
Let me
All
let
right,
my
I'll
colleague.
finish here.
close in
I'll
on
just
this
finish
one.
in
All
saying
right,
this,
all
Mr.
right,
Chairman.
all right.
I think I've made my point as far as how I feel about this. But by the methodology that I hear presented with MML, with Mako, and with your service vendor provider, you know, your methodology would be to, let's just put us, if we really are worried about safety and we want to keep kids safe and everybody safe, by that methodology, we should just have cameras on every yardstick along the highway. We should just put them on every edge of the highway, because that would make everybody be compliant. Because that's what it's about, is gaining voluntary compliance and safety, right?
We would love to work with you on a bill in which we look at where we place the cameras.
It was
and
a yes or no
maybe it's not
question.
every street, but maybe it's every other street, and we'll be more than happy if you want to sponsor that bill.
We're good. I appreciate you, Mr. Carrington. Thank you.
Thank you very much, and go Eagles.
Yes, sir. Thank you.
And
Go
I
Eagles.
would just add, I know that you had referenced Route 40, I think it was, and, so the way that the bill is written is it would affect all of our counties equally, and so I can't speak to that location specifically, but so when I was speaking about, what I was testifying on behalf of, it's the way that it affects all of them.
Yeah, I understand. I mean, my issue isn't just with this measuring device that's being used. My issue is with the whole idea that we set up this framework of an active work zone, that no one's around at the middle of the night at midnight, and a car goes by and it looks like a nuclear bomb went off behind them because it lights up the whole sky because they went through a work zone that's not actually active, but it's active from the moment a shovel hits the ground. That kind of goes against the design of it, in my opinion. So, thank you.
All right. Seeing no further questions, I'll just offer a bit of free advice, and it's worth as much as you paid for it, but we should call it Vision 2020 or Vision 100, not 0, but anyway. All right.
It was 1997.
I know, I get it. There's always an opportunity to rebrand, you know? I mean, come on, you know?
Thank you, Mr.
That's good advice. You take it back to the clients. All right.
Thank you, sir.
All right. All right. With that, that'll conclude the hearing for Senate Bill 11. Thank you, Senator Sidnor, for that. We will now go on to Senator Ellis. You are here. Thank you for your patience. We will start off with Senator Ellis, the Senate Bill 123. Welcome.
Yeah, thank you, Mr. Chairman and Vice Chair. I appreciate being here today in this committee of Judicial Proceedings, my new colleagues, and look forward to a spirited bill here. Maybe not as long as previous ones, but this is my second year bringing this bill before you. Senate Bill 123, Department of Planning, collateral consequences for individuals with criminal records. For the record, I'm Arthur Ellis, Senator from District 28, Charles County. And this bill proposes to ask the Maryland Department of Planning in coordination with the Maryland State Data Center to study, report on, and make recommendations related to certain collateral consequences for individuals with criminal records, and to report to the department and to the MGA by the end of this year on the collateral consequence for people with criminal records. So the question is, what are collateral consequences? So some are described in the bill, and I'll switch to page 1 of the bill. Some of the consequences for folks who have criminal records, let's be clear, they serve their sentences, they're back in the community, and they are faced with quite a bit of restrictions, like in different voting, right to hold public offices sometimes, restrictions on employment in certain professions, restrictions on ability to obtain certain licenses, for instance, like a liquor license, restrictions on the receipt of public assistance, including federal or state grants to buy food. Could you believe someone is hungry and they say, hey, you have a criminal record, we can't give you any money to buy any food for you or your family. And some of those restrictions do exist. Restrictions on international travel, parental rights. Sometimes those are brought into question. Someone who have, let me say again, served their time to society, they're back trying to rebuild their lives, but they're faced with these consequences forever. And these restrictions, I was told by an attorney here who helped draft the bill, could number over several hundred, like a 900 range. They have been around for hundreds of years, and they just accumulate and accumulate. We never do anything to say, hey, this is not reasonable. This doesn't make any sense anymore. Let's revisit that. And so I presented this bill back in 2021. And since that time, DLS issued a report, this is in the fiscal note, and listed some of the consequences and more. And it's a detailed report, but mainly based on, what should I say, occupational restrictions. So there's so many more restrictions out there beyond occupational. I mentioned housing and travel and you name it. It's just scattered throughout our judicial system and our laws here in Maryland. And this bill was a companion bill to a legislation that was presented before this committee, and that first bill to give ID cards to returning citizens, it passed. And you remember, we did a lot of work on that bill in this committee, and there were a lot of nuances that we had to work out, and thank you, Mr. Chair and Vice Chair, for setting up that work group to put in the law the requirements for getting an ID card to those citizens, including they have to get this is a real ID card from the DMV. They had to get a birth certificate. So many folks running around without birth certificates. It's shocking. Had to get a Social Security card. So many people have never gotten a Social Security card. And of course, they had to have some kind of document saying where they reside, Unfortunately, when they're incarcerated, we know exactly where they are. So you worked out those details. We passed a law, and I'm happy to report back that the Department of Corrections has implemented that. I don't think it's as robust as it could be, but coming out of COVID, we're a little patient. So I want to thank you for that. So I'm coming back with this law to look at other problems that affect our returning citizens and to see how, as a body, we can address those problems. So I could go on, but I will not. The evening is getting long, and I ask for a favorable report on Senate Bill 123.
Excellent. Thank you, Senator. We'll take questions at the end from your panel, but thank you for your work on this and in years past. It's great.
Thank you, Mr. Chairman.
Whoever wants to go up next.
Thank you. Good afternoon, Mr. Chair Smith and committee. Thank you for this opportunity to be able to share, opportunity to testify on 123, Bill 123. I am Pastor Gerald Graham, also the Executive Director of Point of Change Jail and Street Ministry in Charles County. Over the years, we've worked over 1,000 inmates in the state of Maryland. I am in favor of the support of this so that we can make sure that these inmates who are incarcerated have a fair chance of getting back into their communities and not be restricted with unable to travel, unable to get their licensing, unable to be productive citizens. So if we could really address this, it would be greatly appreciated, and I look forward to hearing from you. Thank you so much, committee, for hearing me. And again, thank you so much, Senator Ellis, for your work that you're doing in the county. Appreciate you looking out for those that are less fortunate and that don't know all that's going on. So appreciate all that you do, sir. Thank you. Thank you for the time.
Good afternoon, members of the committee. Christopher Dews, I'm actually here representing the interest of the Job Opportunities Task Force. I want to thank Senator Ellis for announcing this piece of legislation. Our governor did just say very forcefully that he is data-driven and heart-led. And I think that a piece of legislation like this goes in that direction where we get that level of information as to what our formerly incarcerated population is experiencing and going through. Bureau of Justice Statistics reported, and this is almost a decade ago, that 1.5 million Marylanders have a criminal record or something that would appear on a routine background check. The American Bar Association acknowledged that there are over 1,100 collateral consequences of having a criminal record, and as Senator Ellis already acknowledged, having to do with housing, financial aid, education, public assistance, occupational licensing, and the one that my client is most concerned with is employment. Looking at housing, if you have a criminal record, you have a subsidized housing can be denied due to prior convictions. 4 out of 5 landlords perform a routine background check on everybody that does apply for housing with them. Regarding education, 3 out of 5 colleges use a background check to screen applicants, and aid can be denied on the basis of prior offenses. Public assistance, depending on the felony conviction, one can be ineligible for SNAP and TANF, and in 2008, over 10 million Americans were unable to receive these types of benefits for the sole purpose that they had a record. Last but not least, well, 2 more, here we go. Licensing. 55 licensed occupations prohibit license renewal or employment due to prior convictions, and over 60% of formerly incarcerated persons remain unemployed up to 1 year after they're released thanks to the criminal record. And that's because up to 94% of employers in the state of Maryland do routine background checks on all of their applicants. So we say that the bill like this can give us the data that we need because the information I just gave to you was out of a report from 2018 from the Job Opportunities Task Force called the Criminalization of Poverty. However, as we say these things, we think it would be better if the information came from the department, from Maryland itself, because, it's just good information and it's much easier for everybody to get access to and for the committee members to sink into. So once again, Senator Ellis, we thank you for the bill, and we urge a favorable report. Thank you.
Good afternoon, Chair, the remaining members of the committee. Welcome to the new members. I'm Elizabeth Hilliard with the Maryland Office of the Public Defender. You will very likely be sick of my voice by April. I know you have already had significant lively debate today, so I will just urge you to review the points in my written testimony. Thank Senator Ellis for introducing this bill. We do think it's extremely important to understand the consequences of the numerous criminal convictions that Marylanders face, and I'm here to try to answer any questions you may have.
All right, questions from the committee? Seeing none, thank you all very much. Thank you, Senator, and I'm looking.
Thank you, Mr. Chair. Thank you, committee.
Thank you, thank you. We have two virtual witnesses signed up, but neither of them are in the room, so with that, that'll conclude the hearing for Senate Bill 123. We'll now move on to Senator Rosapep, who's over there, with Senate Bill 43. Senator Rosapep, welcome.
Thank you very much. You'll be pleased to know that you'll not be hearing much from me this session. But it's great to be back. And I'm back essentially with the same bill that I had last year. And this is all about an issue you guys are very familiar with, which is public trials. I don't know much about the criminal justice system. I've never been a criminal, nor a lawyer, nor a judge. I've been a juror once. But I learned in middle school that the basis of the Anglo-Saxon judicial philosophy was public trials. That star chambers were like in Europe, on continental Europe, but in England and subsequently in the United States, everyone had a right, if they were being charged with a crime and could lose their liberty, that the trial should be in public. Now, when that was established centuries and centuries ago, it was easy to have a public trial because everybody lived in the village and everybody could see what was going on. With industrialization, all the changes we've seen over the past centuries, the fact of the matter is that until recently, particularly during COVID, basically trials were theoretically public, but they were public to people who could schlep their way over, find a parking place, find room in the courtroom, sit there, and observe. But what we learned during COVID, in many ways, we learned with telehealth, we learned with teleworking, that the technology of our time can bring us back to some of the values that established our system, first in the United Kingdom and then in the United States. And so what this bill basically says is the default position should be a public trial to which the public, through our communications means online, just like we're doing this hearing today, can be observed by the public. It has provisions that, for exceptions, whether by state law or federal law or request of those participating in a case and a decision by a judge. So the bill does not say it's public all the time if there's some good reason for it not to be, but it does say unless there's a good reason that a judge rules it should be a secret trial, it needs to be open to the public through our outstanding 21st century means of communication. That's the bill, Mr. Chairman, members of the committee. Oops.
Thank you, Mr. Chairman. Senator, I hope your wife told you last night that she spent the night with me.
She did. She enjoyed it a great deal.
Just so people understand what I'm talking
Yes.
about. The senator's wife chairs or moderates the Stevenson University Speaker Series in the Meyerhoff Hall, and last night the speaker was the author Eric Larson.
Yes.
And we spent a very, very congenial evening together.
I'm glad you offered that
1,000 of our close
clarification.
friends.
Glad you offered that clarification for the record.
Yes.
Appreciate that.
So I do have a couple of questions, though, on this.
Sure.
Have you had a chance to read Scott Schellenberger, the Baltimore County State's Attorney's written opposition?
No.
Can I just read it to you and get you to respond?
Sure.
Okay. He says, I write in opposition, I object due to the fact that when people are in the courtroom, authorities can observe them and make sure no video and audio is being recorded by a cell phone or other device. If people are in their homes, nothing would prevent them from recording testimony and placing it on social media. This type of access and possible recording can place the victims and witnesses testifying in criminal trials at risk. It is currently difficult enough to get victims and witnesses to come to court to testify against those charged with crimes of violence when the testimony takes place in front of relatives and friends of a defendant. Having the ability to watch and listen from home and record the testimony with a cell phone and the ability to put the video and audio on social media puts witnesses at even greater risk. Can you respond to that?
I respond to that by saying that I think that's a reasonable concern, and I understand why a prosecutor would have that concern, but it goes contrary to the fundamental principle of a public trial. And I understand that everyone says bad stuff can be on social media, but I go back to centuries ago, everybody in the village knew everybody's business. This notion that we can be isolated from people knowing what's going on, to me, is an artifact of the 19th and 20th century. It has not survived in the 21st century because of technology. And I think we need to think through how we protect use a scalpel rather than a sledgehammer. I guess what I'm saying.
Okay,
It seems
well,
to me
along
he's
the
talking sledgehammer and I'm talking scalpel.
Your bill provides that unless there's an overriding public interest compelling disclosure, a presiding judge may prohibit the broadcast of any portion of a proceeding on the request of any party witness or counsel involved. So you do make provision for not broadcasting sensitive parts of proceedings. I note that the Office of Public Defender has suggested an amendment to your bill. It says, we propose that the bill be amended to require the presiding judge to grant a defendant's request to prohibit the broadcast of a proceeding. Would you be willing to accept that amendment?
I would defer to the committee's thought on that, because you all know more about these issues than I do. I thought the balance in the draft of the bill that says somebody can raise the issue and a judge has to make the decision seems to me like judicial discretion that's appropriate, but I would defer to the committee on that.
Okay. And then my last question really relates to the opposition of the Judicial Conference, Maryland Judicial Conference, and they primarily talk about questions of cost. They believe that they would have to hire new employees in each of the courts to deal with this program, deal with the technology and turn the system on and off and on and off as required. They think that it would require an additional 124 pins at a cost of over $30 million a year. Do you disagree with that?
I don't know the accuracy of that number. My general experience, as you know, I'm Vice Chair of Budget and Tax, is that agencies that don't want to do things tend to come in with cost estimates that are relatively high, and agencies that do want to do things come in with cost estimates that are relatively low. So I would analyze that in that context.
Thank you very much.
Thank you. Good questions.
Thank you very much, Senator.
Thanks a lot.
Senator West. All right, we'll now move on to, we have several witnesses in support of the bill. Tara Vasefi, coming up. Jade Eaton, Tegan Murphy, and Carmen Johnson.
Hello, Ms. Teagan had to run over to the House because we are speaking at the same time. Yes, so, hello, Chairman Smith and the Honorable Senate. Thank you for hearing our proposed legislation that we hope that you guys will vote appropriately. Well, let me tell you who I am. I am Dr. Carmen Johnson. I am the Director of Court Watch and Judicial Accountability for Prince George's County, a pillar under LAR. I am the founder of Helping Ourselves to Transform. I am the Chairwoman of Advocacy and Legislation for a Reentry Board I was invited to help create with other organizations over a year ago called MSARC under the U.S. Attorney's Office for the District of Maryland. I sit on other boards and committees, including the United Nations. I am a new author of a book called The Pretense of Justice. However, I stand here today in my individual capacity, an impacted Indigenous American woman. I still maintain my innocence today, and thankfully the DOJ in Washington, D.C. is looking into my case. If there was remote access in 2015, when I went to trial, I would not have been found guilty and dragged off to a jail that same day, because many eyes would have been watching what had happened to me. At that camp, I was brutally beat by male guards, stumped, kicked, and spit on quite often. I was strangled once until I passed out. For 31 days, I was ordered under a T5 hot light, and it felt like a microwave in my body. As an innocent woman, I did not deserve this experience, and this is why court remote access, public access is necessary. I train our court watchers to be unbiased and objective when collecting data in the courtrooms. And we have sat in over 5,400 bond review hearings and 200-plus criminal proceedings. 200-plus criminal proceedings over 2 years, and have been strictly remote access in the courts with no behavior issues from the community or our court watchers. This is not 1723, this is 2023, and the technology is there in DC and in Florida. Why can't we have remote access? Please vote favorably to court remote public access for transparency and accountability. No innocent Marylander should have to go through what I went through. And if this injustice happened to me with no remote public access, it could happen to you. Injustice happened in empty courtrooms. Thank you.
Good afternoon. I'm Jade Eaton. I live in Greenbelt, and I'm a volunteer with CourtWatch PG. And I urge you to give a favorable report on SB 43 and assure permanent virtual access to Maryland courts. And I'm going to talk about how virtual access to courts has knit me into my community, made me a better citizen and a better neighbor. Over past years, I had read about the enormous inequities of the criminal justice system in books like The New Jim Crow. But I lived at a safe distance from this, and I told myself I couldn't make a difference until I heard about CourtWatch. And here's what I've learned from court watching. Courts are a place where the holes in our social safety net show up. I see people swept up in the criminal justice system because they suffer from mental illness, who may not be able to get access to the medication or therapy they need in jail, or people who are held in jail for a week or more awaiting a mental health court date to get the services that they need. I see unhoused people who are held, arrested for trespass and thefts of under $100, held on bails they could not possibly afford. Maryland law bars unaffordable bonds, yet we see them every day. I see people who are just hanging on to financial stability, who risk losing their jobs and their homes because they cannot put up a money bond, and pretrial services is backed up for weeks. The people I observe haven't even had a chance to contest the charges brought against them. And even if weeks later the charges are dropped, they do not get their lives back. As people in charge of creating our system of laws, you should welcome eyes and ears of the public and the press in courts. How much could we change our communities if more citizens witnessed the needs that are revealed in these hearings? Please, I urge you to support this bill.
Hi, my name is Tara Vasafi, and I am a DC-based attorney here in my personal capacity, and I'm so grateful to be here. This is my first time in front of the Maryland General Assembly, and as someone who was born in Iran, I don't know if you know what's going on over there, it is a very, very meaningful, it's very meaningful for me to be here and to observe this lively discussion on all these great bills that were introduced, highlighting the vulnerabilities of our justice system. I'd like to urge you to vote favorably for this legislation here, and basically share a little bit about my background in case you have any questions from a technical perspective. Advances in the legal tech world are often seeded by the most vulnerable amongst us. They're the innovators because they are tucking their bodies into the wheels of injustice and recognizing where exactly those vulnerabilities are, as you heard from these wonderful people who participate in CourtWatch and this treasure that we have here in this country in the form of public trials. I cut my teeth in this space. I happen to be one of the first attorneys who was specialized in digital evidence and authenticating social media content or other user-generated content. I did this in various war zones like Syria, Yemen, Sudan. That was where a lot of this innovation was happening because the people most vulnerable needed to have this kind of evidence available. And I discovered the life after release and their practice of participatory defense during the COVID-19 pandemic, and when various citizens were engaged in what's called mutual aid. This is considered mutual aid in the courtroom, how to fill these empty courtrooms so that more eyes are watching how our justice system is being carried out. This legislation is very, very important to improve access to justice, increase participation, improve the efficiency of our legal system, mitigate the harms and effects of overloaded dockets, and also improve transparency and therefore community trust, which is really the key issue here. Thank you so much for your time.
Good afternoon, everyone, again. Was I on your list? I was signed up for it. I just wanted to double check.
Yeah, you're there.
Good?
We just have a long list, so go ahead.
Okay, great, thank you. Good afternoon to everyone again. Again, I'm Sarah Sample from the Maryland Association of Counties, and I am here in support with amendment for Senate Bill 43. So this would require courts across Maryland to fit all the courtrooms with simultaneous remote audiovisual public access. And so for the circuit court specifically, the counties are the ones that fund the circuit courts and the states operate them. And so I think probably in this room, everyone can probably appreciate, what it takes to do what we're doing now with this remote access. It's a very expensive lift, and it's also a very difficult one to do. And so, especially when it's coming to historic buildings and retrofitting buildings that have historic designations. So we just wanted to acknowledge that piece of it, but also we support the intention of this bill. This is something where, it's going to bring transparency, and we think that's a positive thing. So that could serve to fortify, this, an institution, the intent and purpose of this foundational institution. And then the other thing is the ease of access, removing those barriers for low-income individuals. And justice-involved populations that would have a harder time overcoming those barriers. So we certainly support the mission of this, but the amendment would be that the renovations for the circuit courts would happen pending the availability of funding in the state budget. So, thank you.
All right, questions from the committee? Seeing none, thank you all very much. Thank you. We'll now move on to the next panel. It's Matt Hill. I know that there's a simultaneous, they're on the other side, on the House probably. All right, so we'll call Matt Hill if he comes in. Gregory Brown, is Indigo Null still here? Joanne Antoine, DeMarcus Moore, and Dr. Cameron Johnson. Was that Cameron Johnson? Yep. Yes, come on up.
Hopefully you said my name.
Yes.
Okay.
Yep.
Good afternoon, Chair Smith and members of the committee. For the record, my name is Joanne Antoine, Executive Director of Common Cause Maryland, testifying in support of SB 43, which would increase transparency and accessibility to the courts. I think Dr. Carmen Johnson and the panelists before me did a great job of kind of summarizing things, so I'm going to keep my testimony very brief, also so that we can run over to the House. But I think as an organization, we obviously believe that greater transparency creates greater accountability. We've seen that in the work that Court Watch PG, Baltimore Court Watch, and other organizations have been able to do, so much so that they're working with institutions like Georgetown to move forward with taking legal actions. I think beyond that, as the state as a whole, not just the Maryland General Assembly, but agencies throughout the state are moving towards using technology that has long been available to us, so streaming, allowing for remote participation. We think the courts should too. This does provide the judges with discretion when they think needed to I guess you'd say close down or shut down the streams if necessary, but outside of that, I think the concerns that they have regarding funding, the fiscal note says that it would be about 2 to 3 million fiscal year 24 and beyond that, so it's not a huge cost, and it's for a clerk to help assist with the stream. So we do recognize that there's going to be other technology needs, especially if it's an older infrastructure, but this has been working for 2 years. We think that it's doable, especially in the larger jurisdictions, and we'd urge a favorable report. Thank you.
Thank you, Chairman and members of the committee. My name is Gregory Brown. I'm Policy Counsel for the ACLU of Maryland, and thank you all for being here. I don't want to repeat anything everybody else just said, but during COVID, the courts went virtual, as many institutions had to, and even though that was an unfortunate set of circumstances, it brought about a positive change to how we interact with the court system, with people being able to watch the court virtually. And while we are transitioning to a place where we're still kind of in and out of COVID responses and limited access to the courts, there are still other obstacles that people face when trying to access the courts, such as childcare, job-related things, as well as transportation there. And we believe that remote access to the court will increase participation and increase trust from the public. The right of public access to court proceedings is enshrined in both the First Amendment and Sixth Amendment of the Constitution. Public access to court proceedings allows the general public to ensure the justice system is functioning fairly and effectively, providing a check on potential abuses of power. As I said before, transparency in our courts encourages best practices on the part of the government, bolstering public trust, and additionally, public access to proceedings allows people to gain a better understanding of how the justice system works. So with that said, I would like to urge a favorable report from the committee, as well as reading our written testimony. Thank you.
All right, thank you very much. We'll now move on to the next panel. Is William Haynes here? All right, then we'll switch to the opposition panel. I see Steve Kroll is here, Mr. Kroll. And then we will switch to our virtual panel.
Mr. Chairman, members of the committee, welcome back to everyone. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland and the Executive Director of the Maryland State's Attorneys Association. I've been prosecuting cases in the trenches with victims and witnesses since 1984. That's correct, 1984. And in doing so, are opposed and in opposition to Senate Bill 43 and ask for an unfavorable report. There's good news and bad news, Senator Smith and panel and members of the committee. The good news is on February the 7th, the Supreme Court of Maryland, that's what they're known by now, is going to hold hearings directly related to this topic about passing rules that they have under Section 16 of the Maryland Rules. So I'd ask this committee to do nothing until at least we go through the Rules Committee to see what's going on. So that's the good news. The bad news is victims and witnesses who are intimidated. And the bad news is that none of the proponents that I heard here today, haven't read all the written, ever mentioned what effect the court system has on victims and witnesses. In addition to Mr. Schellenberger's report, Senator West, Ann Colt-Lettis, the state's attorney of Anne Arundel County, said the following: the top challenge the prosecutors have in convincing victims and witnesses in violent crimes to appear in court and testify. Witnesses fear retribution by friends or family of the defendants. Based on her experience and my experience, eyewitnesses and fact witnesses are reluctant to provide the most basic evidence to police, often to refuse to be interviewed about the crime, and regularly avoid coming to court to testify. It has become so difficult to find cooperating witnesses, some police agencies do not bother interviewing witnesses at a homicide scene until they first gather video and forensic evidence, and then work from there to identify potential witnesses. As somebody who's been in the trenches, I wish somebody would stand up for, and I'm here to stand up for them, the victims and witnesses of crime. There has to be a balance, and none of the proponents suggested that balance. The right of a fair trial, the right of the First Amendment compared to the right of victim witnesses not to be harassed, and the right of victim witnesses not to have their information shared publicly. There can be that common ground. I will work towards it with the Rules Committee. But as far as this bill, which doesn't have anything to protect victims and witnesses, we'd ask for an unfavorable report. Thank you all very much.
All right, questions from the committee? All right, well, thank you very much. Thanks for hanging in there with us.
Thank you.
All right, we'll now switch to our virtual panel. Do we have anyone in the room?
Yep, Claire Glenn.
Claire Glenn. Miss Glenn, welcome.
Can you hear me okay?
We can hear and see you. Yes.
Okay, perfect.
Hello, my name is Claire Glenn. I worked as an assistant public defender in Prince George's County, Maryland from 2018 to 2021. And while I now live and work in Minnesota, I have remained deeply connected to my colleagues and friends in Maryland. I'm grateful to be testifying today. We are all lucky to live in an age where technology allows us to connect regardless of geographic distance. And to point out the obvious, I am only able to share my experiences with you today because the Senate recognizes the value of virtual access to our governments. We know that virtual access works for the legislature and it works for the courts. During the pandemic, I litigated hundreds of virtual bond hearings in Prince George's County. And while virtual court is never a substitute and certainly needs to be treated with a scalpel rather than a sledgehammer, as we've already heard, I saw how important virtual access is. It allows my clients' loved ones to attend hearings when transportation barriers would otherwise exclude them, which can be the difference for my clients between pretrial detention and freedom. And most importantly, virtual access allows community members to tune in and observe what their government is doing on their behalves. I've submitted written testimony which details my perspective, but I do want to respond to the claim that virtual access invites disruption or misconduct or witness intimidation. First, the courts have many proactive and reactive tools to control decorum and enforce legal restrictions. And in my experience, the tools will need to be used on rare occurrences. Like I said, I've litigated hundreds of virtual bond hearings in Prince George's County, and not once did I observe an incident of virtual access being abused, nor did I learn of a single incident where a victim or witness was intimidated. What I did see was that virtual hearings resulted in court watch volunteers being able to write letters that held prosecutors, judges, police, and even defense attorneys like myself accountable. When they saw something wrong, they spoke up. And while public scrutiny may be uncomfortable, it is so important that those of us working in the court system be held accountable to the constitutional ideals of our respective roles. Thank you very much. I would just urge you to support Senate Bill 43 and keep in mind that injustices happen in empty courtrooms. Thank you.
Excellent. Thank you very much, Ms. Glenn, all the way from Minnesota. Next we'll have, Senator West has a question for Ms. Glenn. Go ahead, Senator West.
Thank you, Mr. Chair. I just want to make sure I understand the bill. So the bill says each court in the state shall provide remote audio-visual public access. I understood that to mean that it's not interactive. It's just I could watch the court proceedings on my computer from home. From some of the things you said, it sounded as if maybe you were thinking that this was going to set up some kind of interactive access so that I could be a witness in a court remotely, or I could ask questions as a lawyer remotely. Is that what you're talking about, or you're merely talking about the opportunity for someone at home to observe what's going on in the courtroom?
Thank you for the question, Senator. It's my understanding as well that the bill would be about virtual observation rather than virtual interaction.
That's what I thought.
Right. I just wanted to sort of offer the more broad experience that I've had with bond hearings, which when I was in Prince George's County up until May of 2021, were all being held via Zoom, which, obviously that's a much more interactive platform as we have now. And even with that interactive platform, the court was pretty easily able to control disturbances and enforce courtroom procedures and decorum and things of that nature.
Right, okay. So I think we're on the same page. If it did involve interactive conduct, it would make it a much more difficult bill. So we're just talking about observation here. Thanks so much.
Thank you.
All right, thank you, Ms. Glenn. Seeing no further questions from the committee, we'll move on to the next witness. Sophie Holmes. Is she still in the waiting room? You are. Ms. Holmes.
Hi. My name is Sophie Holmes. I lived in Maryland for about half of my life, but now I'm attending college at the University of Vermont. I have volunteered at Court Watch Prince George's County for a few months, and I'm writing in support of Senate Bill 43. I support it because it's very important that court hearings are transparent so that judges can be held accountable for their decisions. Continuing to allow remote access to court hearings means that more people will be able to observe them, leading to a more equitable system. I support the bill because of the things I've seen as a court watcher. People are subjected to injustices every day, like being held in jail because of an unaffordable bond, being denied their medication, having their medical needs ignored, or ending up back in jail because they weren't able to receive their hearing date notices due to homelessness. Allowing remote access will let more people observe the courts, and that is the first step to fixing these problems. Remote access is vital to the community because everyone has a right to open in public courts, even if they can't be there in person, because they couldn't afford transportation or take time off work. I believe that legislators should support this bill because it will allow for more equality and transparency, which is what a court system should always strive for. By continuing to allow remote access to courts, everyone will be able to attend court hearings despite their circumstances. And in addition, it makes it easier for family members and friends to attend their loved ones' hearing for the same reasons that I mentioned above. Thank you.
Excellent. Thank you, Ms. Holmes. Thanks for taking the time to testify with us here today. No questions from the committee, so we'll move on to our next witness. Thank you all. All right, here we go. Thanks. Ms. Mills, you're up. Welcome.
Good afternoon, committee. I won't go into a lot. I submitted my written testimony as well, but my name is Bianca Mills. I'm a resident of Prince George's County, Maryland. I'm a family member first, and I'm Community Outreach Director of Life After Release secondly. And I wanted to speak on why I think that SB 43 should be supported by you guys. 2 years ago, my son 2 years ago, had a case, and with my family members being out of town, they caught COVID, and they were unable to attend court for him. And so for that, if remote access wasn't available, they would not be able to attend outside of court. Court was also closed because of the pandemic. It was during the pandemic. And so therefore, 67 community members were able to all at once be on the Zoom at once and support my son. And I really truly feel that it made a difference in his outcome. I believe that the bill 43 should be supported because it affects predominantly the Black and brown folks who are unable to leave work, who don't have babysitters, who don't have transportation, and transportation is on the rise now. It's hard to get from, I live District Heights, to get from District Heights to Upper Marlboro. So I hope that the Judiciary Committee favors and votes for SB 43. Thank you.
Thank you, Ms. Mills, for taking the time. Seeing no questions from the committee, we'll move on to Ms. Wilson. Ms. Wilson, welcome.
Thank you. My name is Odessa Wilson. I am a resident of Highland Springs, Virginia. I recently received my Bachelor of Science in Psychology from CTU University. I am a part of the Life After Release program based in Prince George County, Maryland. I'm writing in support of the SB 43 bill because it's important that the court hearings are transparent and judges are accountable for their decisions as possible. Continuing the allowance of remote access to hearings will ensure that more people have the ability to observe the way the justice system works. This in turn will lead to an overall more fair and impartial justice system in the future. I'm also supporting the bill due to the things that have been brought to my attention during time as a court watcher. Many injustices are experienced every day, such as remaining in jail due to an unpayable bond or being denied medication only to be sent to mental health court to receive more jail time. These injustices also include things such as being incarcerated for missing hearing notices due to homelessness. This bill is essential because allowing people to observe a court of law in action will reduce the chances of this happening. The fact of the matter is that these injustices now often happen to Black and brown people within our communities. In addition to that, the cost of transportation is steady rising. this should support the bill as it would allow impartiality and transparency within the court system. It is something that I believe should be a goal to be reached in the near future. Also, many people cannot afford public transportation or take the time off to appear. This will cause the population of the population of the court to be unfair and jagged. By continuing to allow remote access, individuals, no matter their circumstances, can attend court hearings for themselves or family members. Thank you.
Ms. Wilson, thank you very much for taking the time to testify today. Seeing no questions from the committee, that will end the hearing and the testimony for Senate Bill 43. Thank you, Senator Roosevelt. And for our final bill of the day, we'll go on to Senator West with Senate Bill 58. Senator West.
Thank you, Mr. Chair. It's a pleasure to be here to present Senate Bill 58. This is my first bill of the session. There will be others. Also, this is probably the least interesting of all my bills because it covers a very complicated subject area. This is the annual bill sponsored by the State Bar Association's Business Law section on technical changes and upgrades to Maryland's general corporation law. Those of you who, well, there are only two here at the moment who have been here in prior years, but you will know that each year the business law section brings a bill like this to cover miscellaneous changes to the corporation law. I really appreciate Senator Wallstreicher for co-sponsoring this bill. Next year it'll be his turn to present this bill. The provisions in this bill are complicated and highly technical. Let me just quickly summarize them. On page 3, the bill clarifies that a corporation may not issue a stock certificate in bearer form. Most corporate lawyers, noting a Maryland corporation law provision requiring that a stock certificate must state the stockholder's name, consider bearer form certificates as improper. But the Maryland General Corporation Law currently does not expressly prohibit them. With the new Federal Corporate Transparency Act and concerns about money laundering, Maryland's corporation law should be clear on this point. On page 5, the bill further states that bearer form certificates cannot be issued by limited liability companies. On page 6, the bill provides that a non-stock corporation's charter may provide that an individual may serve as a director merely by virtue of an office that the person holds within the organization or in another organization. On pages 7 and 8 of the bill, language is added to the Corporations and Associations article, setting forth the procedure for terminating the existence of real estate investment trusts. That's probably the longest provision in the bill because there's currently nothing in the law talking about how one terminates real estate investment trusts. So the bill provides the procedures for doing that. And then the bill also clarifies the circumstances in which the owners of statutory trusts formed under the Investment Company Act of 1940, such as mutual funds, may be governed by a section of the Maryland Code that sets forth the voting rights and stockholders' meeting rules. I appreciate the committee's consideration of Senate Bill 58. Hope for a favorable report. With me, sitting next to me at the table, is a fellow who the longtime members of this committee will recognize. Bill Carlson is the president of Shapiro and Share. He's the MSBA Business Law Section. He's on the section council, and he's the chair of its committee on corporate laws. He can explain and answer questions about this bill, which I probably cannot. So I turn it over to Bill.
Thank you, Senator West. Appreciate that. Chair Smith, Vice Chair Waldstreicher, members of the committee, thank you for listening here to me. I'm Bill Carlson, Chair of the Maryland State Bar Association Committee on Corporation Law, and as Senator West explained, we come here every year with new developments, clarifications, improvements. With Senator West having explained some of these provisions better than I will, I'll just won't repeat him, and I want to hit one, which is probably the most important item. I think all of us know or have experienced the concept of ex officio directors. So you may have, in a nonprofit, other non-stocks, but primarily nonprofits, they might say that the county executive is automatically on our board, or the president of the hospital next door, or some affiliated organization, or pastor so-and-so is automatically on our board. And technically, under Maryland law, you have to elect that person you have to say Pastor Smith. You can't just say pastor of that church. In practice, however, many nonprofit charters and organizations just name an entity, name an office. They don't name a person. They don't bother electing a person. This has caused issues when there are legal battles sometimes over proper corporate form. Counting someone as in a quorum, counting that person's vote. So we're doing what a few states have done. We're kind of getting out ahead of some stuff. We're enabling non-stock companies, not companies with stockholders, to say, you can automatically say that Pastor so-and-so, county executive so-and-so is automatically on our board. And so, and that's kind of what's done in practice by many people. So we're trying to recognize what actually happens. So if you have any questions on that item or anything Senator West mentioned, any other ones, I'm happy to answer questions.
Well, Mr. Carlson, thank you for being here and waiting all day for the least interesting bill in your assortment there. But I'll say, look, let's I
enjoy listening to all this. I mean,
I'm
like,
sure you
the
did. I'm
important
sure you
things.
did.
So,
We'd like to work on this just so that members can understand. So I assume we'll pipe you in through Zoom or something like that when we work on this bill.
Okay,
if you're
please
amenable
do.
to that.
Okay.
Okay. Excellent.
Thank you.
No questions from the committee. Thank you very much. Thank you, Senator. And with that, that'll conclude the hearing for Senate Bill 58 and our hearings for the day. As a reminder, tomorrow is a day that members should use to work on their bills and perfect them, convene work groups, engage the opposition, work things out, so that we can have a smooth week next week. So, Friday
we have a virtual hearing.
Friday, we have a virtual hearing on judicial elections, and it's a pro forma session, so just be aware of that. And so with that, that'll be it.
What time is our hearing on Friday?
1 o'clock. All right, have a good evening.